No, not no. Anybody but McDuffie. You got everybody there to choose from, and you pick McDuffie. Okay, Miss McDuffie, go ahead.
Good morning. The people waive any conflict between this honorable court and the office of the public defender for all cases on today's docket. The people do not believe that a conflict exists, but we make this waiver for the avoidance of any conflicts.
I'll blame you, Childers. Oh, I get a choice? You know who I'm choosing. No, Miss Mackey?
Zero under Deputy Chief Laura Brown.
Permission to practice is granted.
Thank you, Your Honor. Honor, we waive any potential conflict honorable court and our office with the conflict to provide to waive that conflict with honorable court in any matters.
Thank you. That was so nicely done. The court, for its part, does not believe that there is any conflict either under the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of People State of Michigan versus Gene Giles. They're all on Zoom.
Good morning, Your Honor. For the record, Rita Young, P44626, appearing on behalf of the defendant, Mr. Gene Giles, who is present by Zoom.
Sir, can you state your name?
Gene Gillis.
Gillis. All right, thank you. All right, what are we doing on this?
Your Honor, requested a preliminary examination in person.
And you have all of the discovery?
I'm still waiting on the DNA test results, Your Honor, but I don't want to, we've been waiting for a while, so I want to move forward. Hopefully the prosecutor will provide those documents before the exam date.
I have a note from APA Ronnie from the last CC where she stated, she sent an email to Ms. Young, and Ms. Young actually replied to that with confirmation. She stated that she was able to confirm with the plan that there will be no further testing on this case, so we can go ahead and send this court to. So no DNA results are important.
There. Did you hear that?
Not clearly, Your Honor.
There'll be no DNA testing. There's no further testing. There'll be no DNA results coming.
Okay, very well.
All right, since we got to arrange for transport from MDOC, preliminary examination in person will be set April 22nd.
Judge, I have a conflict.
Pardon?
I'm so sorry. I start a homicide trial in Wayne County on the 21st. That's going to last about a week.
April 29th, 2025, 9 a.m. That is before. That's before me.
Okay.
Just call me lucky. All right. Thank you.
Thank you, Your Honor.
Bond continued. Thank you, sir. Court calls the case People versus Robert Braxton.
Morning, Your Honor. This is Court David Bergson and Robert Braxton, who's appearing via Zoom.
Mr. Braxton, can you state your name, please, sir?
Robert Braxton.
I have before me a plea form. Is that what we're doing?
It is, Your Honor. I discussed it with my client. He's ready to proceed.
All right. Plea form indicates that the defendant will be pleading guilty to 2 charges, added counts 5 and 6. The 5 being attempted possession of a firearm in a motor vehicle, a misdemeanor punishable by up to 1 year incarceration, and a $1,250 fine plus court costs, and then added count 6 of attempted resisting and obstructing a police officer, also a misdemeanor punishable by up to 1 year, $1,000 fine plus court costs. Upon a successful plea to that charge, counts 1, 2, 3, and 4 would be dismissed, and there's no objection to a time served sentence. That's the court's full understanding of it.
That's perfect.
Mr. Braxton, can you raise your right hand, please, sir? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name again for the record, please.
Robert Maurice Braxton.
Sir, it is the court's understanding that you're going to be pleading guilty to 2 misdemeanor charges. First charge being an added count 5 of attempted possession of a firearm in a motor vehicle. It's indicated that's a misdemeanor punishable by up to 1 year incarceration and/or a $1,250 fine plus court costs. Do you understand that?
Yes.
It's also this court's understanding you're going to plead guilty to an added count 6 of attempted resisting and obstructing a police officer. That being a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge unless we proceed to immediate sentence. Did you understand I would not be your sentencing judge? We would be sentenced before Judge Washington in the 14B District Court.
Okay. I thought I was going to get sentenced today.
Mr. Braxton, but I'm not sure if Judge Simpson's going to do it or not.
They never know what I'm going to do.
Okay.
All right. The good thing is neither do I. What?
While I would like, I would be fine with immediate sentencing, the reality is the constitutional attempt.
Yes, it is. I have to send it to Judge Washington. Because it's a DR. You're right. All right. So you understand that, sir? Mr. Braxton? Yeah, we've lost it. I've lost the audio. Let me pass the matter for you. Can you put in the chat so that you can't? Okay. Court does call the case People versus Jenny Liu. 2 cases.
Assistant Public Defender Chelsea Burfield, with and on behalf of Jenny Liu. Please state your name.
Jenny Liu.
Good morning. All right. You're asking for an adjournment of this.
We have been able to visit further results and attorney on another case attempting but unsuccessful
To
follow the process of getting a visitor and then scheduling. Ms. Tierney has gotten her step 1, but now she's having to go to step 2. I have not even approved as a visitor, unfortunately.
All right. Is anybody in your office aware of how much time this is taking? Because this is the first case.
We are definitely aware and we apologize for that, but we are trying to follow the extensive instructions provided to us by Grand Valley's facility.
Right, I understand that, but are we looking at a month or are we looking at a shorter time period?
I would say a month to be safe. Now that Ms. Kearney is approved, once the scheduling spot opens, she should schedule that and discuss the offer with her.
All right. Probable cause conference, April 24th, 2025, 9 a.m. Bond will continue. Thank you, Miss Liu.
So Judge, am I just waiting for them to come see me?
In part, yes, they have to come talk to you, but they've got to get through the process to even be able to have a visit with you.
The visitation. Yeah, I was aware that. I thought they had already got that all cleared up.
Whatever it is, not just because of your case, but it seems to be a mess on MDOC's part, trying to get people approved. So I know they're working on it hard with your case and with other cases. All right?
Okay, sir. Thank you.
All right. Thank you. Court calls the case of the People versus Devin Gibson.
Please, report Brandon Berg on behalf of Devin Gibson.
He's in. Okay.
Yes.
Sir, can you state your name?
Me, Devin Gibson.
All right. What are we doing? You're requesting an adjournment?
Yes, sir.
Probable cause conference will be adjourned. It's 2 weeks out, the 10th. April 10th. Will that work for you, Council? April 10th, 2025, 9 a.m. Your invite indicates bond will continue.
Commission to the president.
Go ahead.
18-year-old lifelong resident He is public in possession and since matter. We do have his father here to support him, so he has significant community ties. He understands that there's gonna be no contact when the witness and respectfully honored. My client indicates to us that even if he needs his tether,
Go ahead. You know what I'm saying?
whether we respectfully request the personal boundary tether, at least to lower it.
Response.
Thank you, Your Honor. First, I want to ask if the court has a copy of the prosecutor's bond recommendation form in its file.
I do.
I wanted to ask if the court would respond to that. You will see that the authorizing APA on this case originally requested a cash or financial bond of $500,000 as surety. I believe that what was actually ordered was significantly reduced amount, if I'm not mistaken, of $50,000 with a 10% privilege on top of that. I think the recommendation form will get into detail about some of the concerns on these cases. There is GPA charged, and there was apparently a very bloody statement in residence, including several counts of RNO with damage to a police vehicle and an intimidation charge as well. So we're very concerned about the safety of the community in general, based on what happened. So the people would ask that it's significantly responsible for originally requested.
Anything additional, Counsel? Motion for bond reduction is denied. Bond will continue. Thank you.
That's it, Craig.
Court calls
You
the
do
case
that
people
today, girl, once
versus
you put her
Warren.
hands on me, though.
Oh. Do we need to go back up? Okay, no. No? Leave it alone? Okay. You're a nicer person than me. Court calls the case people versus Warren Abbott. Wow, in the room. In the room. In the room. Thank you, sir.
And Your Honor, I spoke to my client about options in the past. He has elected to waive over to circuit court.
All right. Is that correct, sir? You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand you'll not have that here. You'll proceed to circuit court for further resolution. People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on a single charge. Ms. Cannon.
Your Honor, at this time, my client will waive from the information, and he standing as to the charges.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
April 9th, at 1:30 before Judge Conlon.
April 9, 2025, 1:30, Judge Conlon.
Thank you, Your Honor.
Thank you. Bond will continue. Court calls the case of People versus Rafael de la Cruz.
Good morning, Your Honor. This is Robert Ianni, Special Assistant AG on behalf of the people.
Under Alexis, I'm appearing with on behalf of Mr. De La Cruz.
State your name, sir.
My name is Rafael de la Cruz.
All right, thank you.
And Your Honor, we are requesting an adjournment. Mr. De La Cruz posted bond at the end of February. Since then, he's paid an additional $2,000 towards his arrears. So we are just asking an adjournment.
Any objection from the people?
Yeah, we would like to see him start making monthly payments, Your Honor. He does have 2 children in need of support. I mean, I don't mind dragging this case on as long as he's making his monthly payments.
How much are his monthly payments?
Your Honor,
$350, Your Honor.
$350. He paid the additional $2,000 at the beginning of this month, which went obviously toward the arrearage as well as his monthly payment. So
That's correct.
All right. All right. How much time were you looking at?
if we could go out a month.
Probable cause conference, April 24th, 2025, 9 a.m.
April 24, have it, Your Honor. Thank you.
Thank you. Bond continue. Court calls the case People versus Stephen Bauer.
again, Your Honor, make so for David first. I'll be able to see the approach.
All right. And you're requesting time to get the
2 weeks, Your Honor.
2 weeks to do?
Pretty much to review some discovery, and we're not sure if there is additional discovery, but we need to review it anyway, so we're requesting 2 weeks. That's correct, Your Honor.
April 10th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus James Belleville.
Edward Hoops on behalf of James Belleville.
Mr. Belleville?
Yes, Your Honor.
All right.
Good morning, Your Honor. We have been working on paying restitution. I can provide a check to you, but I understand that we're to pay restitution, that's in cash.
Yes.
So we're looking to try.
And it needs to be paid at 14B. Yes.
I'm going to work on facilitating that, and I have 2 weeks.
2 weeks. Without objection, probable cause conference April 10th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, sir. Court calls case People versus Stevie Brooks.
Yes, Your Honor. Run a bird on behalf of Steve Brooks. State your full name first. Steve Brooks.
Thank you. All right.
Your Honor, maybe briefly approach on this matter.
Counsel too? Yeah. Yeah. Okay. Come on. Record should reflect we've had a brief bench conference in this case. All right.
Yes, Your Honor. We'd like to set this matter for
Preliminary. All discoveries complete, counsel. All right. And would the people have their witnesses available the 8th? All right. Preliminary examination in person, April 8th, 2025, 9 a.m. That's before Judge Balbo. Bond, go ahead. Do you want to address Bond?
Especially my clients in the city, my clients in jail working with me, I do understand that you have previous actions, my client reached out on the phone, but he understands the consequences of those actions at this moment. Especially, his phone privilege is public right now. He does have a lot of business that he needs to attend to, at least to sort of keep his life going. He's closely nothing in innocence at the moment, and if he is found to be innocent, and his life will be impacted significantly by him sitting in jail, or at least not being able to make any phone calls and handle the jail. I do understand these are serious assault allegations, but my client is ready to face those allegations, maintaining his innocence in this matter, and respectfully, Your Honor, we're asking the honorable court give my client a chance, even if it's with the GPS tether, or even if we at least become more lenient on his phone call, so that he's able to keep like some sort of balance while he's locked up.
Respond.
Judge any modification of bond. As the court heard, he had previous jail calls that weren't addressed that were to the victim after he had been arraigned. He also has numerous dismissed DV cases. He has a 2021 under dismissed firearms DV cases, and in these cases, there's at least 4 instances of him terrorizing the victim, in which he is throwing things around the house, taking her phone, pushing her against the couch, taking her phone again, pushing her on her chest, grabbing her wrist, pushing her around the house, taking her phone again, throwing her down on her stomach, stomping on her back, grabbing her by her hair, slamming her to the floor, and choking her. So I have extreme concerns for her safety and would object to any modification of bond.
That's allegedly, that's alleged. My client has proven that they have performed those actions against that person. I ask you, please don't use this domestic violence prosecute domestic violence cases against my client, or at least assume that he's guilty or that he has something to do with those cases. Because if we want to make assumptions, we could assume that somebody may be lying on him and trying to use the police against him because of what they might be going to do in their relationship with my assault scenario. So, especially, Your Honor, we're looking at this case on its face. I do understand this assault connection. I do understand we have that phone call. But my client got his phone calls recorded. Not able to speak to anybody. Been sitting in jail over 2 weeks. He understands the severity of those.
Yeah, but that's by his own due. I mean, it's not as though we just decided to sort of hold him incommunicado. The problem is that he couldn't follow the conditions as we laid them out. So if I released him, what would make me think that he would follow any of the conditions that are set right now? He didn't do it before.
Ways to mitigate that, Your Honor. There's ways to mitigate that with GPS even if it's house arrest. With a GPS test, if he steps out that house, then he's gonna be arrested.
Couldn't follow the conditions when we first gave him to him. Motion for bond reduction denied. Bond will continue. Thank you. Court calls the case People versus Julian Word.
Christina Costantino, appearing on behalf of Mr. Word. Mr. Word, can you unmute, or ask someone to help you unmute and state your name for the record?
I'm unmuting. Julian Word.
So this is a date and time set for a PCC. At this time, we would be asking for an adjournment so that I have some additional time to review discovery with my client, Spring House at Wayne County Jail.
All right. Did you want the 10th or the 17th?
The 10th would be great.
All right. Without objection, probable cause conference April 10th, 2025, 9 a.m. Bond will continue in this case. All right.
Thank you very much, Judge.
Thank you. Court calls case People versus Derek Graham.
And then on behalf of the Your Honor.
David Goldstein, on behalf of the defendant. Your Honor, I was just recently detained in this matter. I do have the written discovery. However, I was informed this morning that there is some electronic media that I have not received. So I'm asking for one witness.
Will all of that be provided within a week?
Yeah, you already have it in our file, recent Senate to
Probable cause conference then will be adjourned April 3rd. Both matters, 2025, 9 a.m. Bound continue. Court calls the cases of the People versus Samantha Warren. All right. Your name?
There should be a waiver while we're.
You're waiving on all 4 cases?
That's correct.
All right. Ma'am, is that correct that you're waiving preliminary examination in all of these matters? You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand you'll not have those hearings and you'll proceed to circuit court for further resolution. People also waive their right on all 4 matters?
Yes, sir.
Preliminary examination having been waived on the single count in each of these cases, defendant is bound over to circuit court. Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial in these matters will be set for May 19, 2025, 1:30, Judge Hammoud. Bound will continue. Thank you. For cause case People versus Don Lee, 2 matters.
So we're going to say first having 2 patients.
Your name, sir? Thank you. You're requesting an adjournment?
Yes, Your Honor.
Couple weeks will work, or?
Yes, sir.
All right. Without objection, probable cause conference April 10th, 2025, 9 a.m. Bond in these matters will continue. Thank you.
Your Honor, could I have one request?
Certainly.
I know we had last week, phone call, issues, phone calls. And I'm still listening to the calls and we'll file a motion if appropriate. Mr. Lee is wondering if he's able to at least call his brother instead of having all of his calls restricted. Is that possible to work out?
Any response?
Your Honor, we would have a strong objection that he was mailing letters to his mother to get in contact with him. That was
And I recall all of that, so I'm going to deny that request. Court does call the case People versus Larzell, Washington.
Good morning, Madam. Edward Rubens on behalf.
Okay, Chip it.
I'm requesting an adjournment.
Are you? Your client would request it if they were here. What a concept. Yeah. A week would be enough? Yeah, okay. Bench warrant will issue for defendant failure to appear. Bond is set in the amount of $10,000. Cash surety, that warrant will issue immediately. Thank you. Court does call the cases of the People versus Tyve Mills. 3 cases.
And your children preparing on behalf of the people.
On all 3.
Yes, right.
Counsel first. Or would the people have their witnesses available the 8th?
I was going to say, Judge, my only issue, Judge, is that I am in trial Thursday, 7th, 8th, and 9th. If possible, if you could the following week at all.
The 15th?
That will work, Judge.
Any?
I was actually going to ask, just there, because of the number of witnesses in cases, I was going to ask.
All right. And that's going to be, I'm going to keep this one. Preliminary examination in person, April 15th, 2025, 9 a.m. That's before me. On all of these matters.
Thank you, Judge.
Got there anyway. Bond will continue. Thank you, sir. Yeah. No, it's okay. Court calls the case People versus Robert Trombley.
And your children preparing on behalf of the people.
Yes, Your Honor, Brandon Bird on behalf of Robert Trump.
Thank you. All right, what are we doing?
We would like to set this matter for the time.
All right. All discovery is complete. Would the people have their witnesses available the 8th?
That's fine.
All right. Preliminary examination in person, April 8th, 2025, 9 a.m. before Judge Barr. Bond will continue. Unless you wanted to argue it, counsel. I mean, no, okay, all right, I'm just, okay. All right. Thank you, sir.
Bye.
All right, take care, sir. Court calls the case, People versus Jeffrey Stoops.
Your Honor.
Public defender on behalf of Mr. Stoops in the case ending in 1740.
Your name, sir? All right. You're requesting an adjournment.
I am, and I do believe Mr. Drew is did say to me he was requesting an adjournment in my case, or in his case as well. Mr. Stoops has been referred in my case to the 14B Recovery Court. I've been in contact with Mr. Reyes down there. He has not yet been down to jail to screen Mr. Stoops, but he states he is going to. I believe that'll be done sometime early next week. So I'm just requesting a 2-week adjournment of my case.
I have the written form. Where's Mr. Drukas?
Right in that hallway. He did say he was going to adjourn it at 12.
Yeah, I know, but I have his client. I need the attorney. I mean, hey. Mr. Drukas, you're requesting an adjournment also on Mr. Stoops? Yes. All right. Yes. Hold on one moment. So how much time? There's a referral that has gone over to 14B. I presume you're tagging along with that. So where is it in that process?
I would just ask for 2 to 3 weeks, Your Honor. Mr. Ray hasn't met with Mr. Stoops yet, but said that it's on soon. So I don't know for sure if it had been answered within 2 weeks, but I would ask for 2 to 3 weeks.
All right. Why don't we do the April 17th, 2025, 9 a.m. Yes, as to Bone.
That he has made 51 calls since his arraignment to the victims. He's been calling his phone, but it is the victim that answers. In talking, they use a code name calling her Aunt Diane, but it's the victim. So we would have concerns that he's contacting her by using his own phone number and that's his phone number.
With regard to that, I haven't heard anything. So.
Any response to that? You're presuming it's not on your case. Well, you'll be entitled to certainly file a hearing once you hear all of the calls, but at this point, I'm going to revoke the defendant's phone privileges. His bond in each of these cases will continue.
Thank you, Your Honor.
You know what? When I call you, I'm going to use a code name. Yeah, no, I'm going to do that. I think because that'll work. Calls the case. People versus Joseph Hamby.
Good morning, Your Honor. Victoria Burton here as Chief Assistant Prosecutor appearing on behalf of the people.
Good morning.
Okay, on behalf of Mr. Gary, evaluation 24F1-1672.
And Carolyn Foster Tucker on behalf of Joseph Nancy in the case that he had died.
So you can take this record.
All right. On your case, you're waiving.
Yes.
What are we doing on the other case?
We're going to set that one for a preliminary exam.
All right. So let's set, discovery is complete on that case.
Yes, Your Honor, that's my knowledge.
Would the people have their witnesses available on the 8th?
I see no reason why we wouldn't, Your Honor.
All right. Preliminary examination in that matter will be set in person, April 8th, 2025, 9 a.m. That is before Judge Balvo. In that matter, bond will continue.
Thank you so much, Your Honor.
Thank you. In the other matter, so you're waiving your right to a preliminary examination? You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. All right. You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution. All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Go ahead.
Wait for all readings and standing charges.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial in this matter will be set for May 19, 2025, 1:30, Judge Hamoud.
Thank you, Your Honor.
Thank you. Bond continue.
Thank you, Your Honor. One of my staff
Thank you.
can find that information about the children's.
Yeah, they're all like all out of control here, Ms. Burton Harris. So we'll see if we can track one down. It's been something this morning.
Doing their best, Judge.
All right. Thank you. Court calls the case, People versus John Zock. Well, he's coming out. Mr. Braxton, can you now hear me?
Your Honor. It's always good to see you. Robert Ellman with, on behalf of that's
John and
All right. Good morning.
Your Honor, they take concept of probable cause conference. We will be waiving preliminary hearing at this time. I believe you could have a sign with
I do. So you're waiving your right to a preliminary examination? You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed.
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right? Preliminary examination having been waived, defendants bound over to circuit court on counts 1 through 4 with 5 and 6. Mr. Allen.
Yes, Your Honor, and we would waive any formal reading and standing.
Defendant having waived formal reading, standing mute as to all counts, court will enter a not guilty plea. Pretrial will be set for April 9th, 2025, 1:30, Judge Conlon. Bond will continue.
Thank you, Your Honor.
Thank you.
Great day.
You do the same. Mr. Braxton, can you talk back to me now? I don't know what's going on. Mr. Braxton, if you can hear me, wave your hand. Now, this is even worse because I'm getting nothing now.
Yeah.
I'm not getting a response at all. I think that's frozen. Yet we're gonna have to. We'll try to get it through. I don't know. Court calls the case People versus Isaiah Levy.
Good morning, Your Honor. Victoria Burton here as Chief Assistant Prosecutor appearing on behalf of the people.
And good morning, Your Honor, to the staff and people of the Honorable Court. Mohammed Nasser, P7445, premise of half of Mr. Isaiah Lee. If you're standing to my right, sir, state your name for the record. Isaiah Lee.
Thank you. What are we doing?
Judge, may I please report, I didn't realize the attorney of record would be the deputy chief. I didn't have a chance to speak to him. We did receive discovery yesterday. However, your staff did advise me that we failed to file the substitution of attorney. I'll do so immediately. I'd like to set this for a new PCC so I can speak to the prosecutor in regards to the resolution. I'll wait 14, 21 day rule, Judge.
Probable cause conference, April 10th, 2025, 9 a.m.
Thank you so much, Judge.
Thank you. Bond continue. Court calls case People versus Christopher Willis.
Andrew Childers, bring on behalf of the people.
Edward Roots on behalf of Mr. Willis. Your Honor, may I have a question, President?
You may. He still has a current bench warrant out on it, but it shouldn't be. It should have been canceled on his arraignment. Yeah. Yes, it's been revoked. All right. Record should reflect we had a bench conference in this case. Probable cause conference will be adjourned for 1 week to the 3rd, April 3rd, 2025, 9 a.m. Bond will continue as revoked. Court calls case People versus Amin Benin.
And then I'll be back. Your Honor.
Well, Your Honor, this is a public defender conference. Right, sir, full been record.
Amin Benin.
Thank you.
Your Honor, today's the date time separately. Submit the assignment with respect to the question separately.
All discoveries concluded. People have their witnesses available the 8th.
Your Honor.
Preliminary examination in person, April 8th, 2025, 9 a.m. Bond or before Judge Bar. Started going someplace else. Bond will continue. Thank you. He moved. Mr. Braxton, can you hear me?
I can hear you now.
Okay, now we can hear you too. All right, they got us straight, I think. I'm gonna call that case. The court recalls case, People State of Michigan versus Braxton.
Andrew Childers, bring on behalf of the people.
Morning again, Your Honor. May it please the solemn court, David Ferguson and Honor Braxton. Is again appearing with me in the Michigan Department of Corrections.
All right, and I think we had gotten to the point where I had apprised you of the charges and you understood the charges you're pleading to, correct, sir?
Correct.
And you understand that because of count 2 with the victim's rights case, I can't do immediate sentencing, so you understand that?
I do understand that.
Okay, very good. So, sir, to the charge of attempted possession of a firearm in motor vehicle, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing a police officer, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak to you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
I do.
You understand you're giving up your right to appeal of right?
Yes, I do.
Are you on probation or parole?
No, I'm not.
Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily and of your own free will?
I am.
And because you believe that you're guilty of these offenses?
Yes, sir.
April 4th, 2023, at the location of 2861 International Drive, Ypsilanti Township, Washtenaw County, State of Michigan. Were you in a motor vehicle?
I was.
Did you have possession of a firearm while you were in that vehicle?
There was a gun in the car, yes, sir.
Okay. And did you know it was in the car?
Yeah.
Yes? Okay. Thank you.
Yes.
And you didn't have any authority to carry that weapon in that fashion, did you, sir?
No, sir.
All right. You, at some point, came into contact with police?
I did.
Probably didn't go well. What happened?
I tried to run.
Oh. That didn't work.
No, sir.
You knew they were trying to arrest you?
Yes.
All right. Counsel? All right. Court will accept the defendant's plea of guilty to counts 5 and 6. Counts 1, 2, 3, and 4 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this case will be May 1st, 2025. What time? 10 a.m. before Judge Washington.
Okay.
All right.
All right.
Bond will continue. All right. All right. Thank you. Take care of yourself, Mr. Braxton.
All right. Take care.
Court calls case People versus Gerard Brown Hughes.
People, Your Honor. Stephanie Cannon on behalf of Mr. Brown Hughes.
I could have got nothing. All right, what are we doing on these cases?
Your Honor, Mr. Hughes is going to pay circuit.
In both matters?
Yes, Your Honor.
Is that correct, sir?
Yes, sir.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand that by waiving that proceeding, you will not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
All right. People also waive their right in both cases.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count in the case ending 1101 and on count 1 with 2 following in the other matter. Ms. Cannon.
Thank you, Your Honor. We would waive formal reading of the public information and standing on the charges.
Defendant in every way, formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for April 7, 2025, 1:30 before Judge Simpson.
Thank you, Your Honor.
Thank you.
Thank you. Bond will continue. Call the cases of People versus Beverly Boss. They need to sign off.
This is public defender Natalie. Probably with on behalf of Ms. Boss, who should be dialed into the Zoom here. She called the public defender's office this morning. She talked to several of the legal assistants. She's actually sick, and she was having trouble logging onto the Zoom, but I believe she was finally able to successfully dial in. If she's using her father's phone, the last 3 numbers are 238.
Nope. I have one call in.
I'm not sure if that's the number she's using. If it's her father's phone.
Ms. Boss, if you called in on Zoom, I only have one number, but if you called in on Zoom, you'll need to hit *6 on your phone to unmute.
Hello?
Oh. Hello, what's your name?
Hello. Beverly Boss?
Oh, that's her.
Yes, that's me.
So, Your Honor, I have discussed this matter with people. I was planning, Ms. Boss and I have not been successful in having a phone conversation prior to today. I was going to give her an update this morning in person, but obviously was unable to be accomplished. I would ask for one week loud. I understand if it's going to be.
It's going to be 2 weeks.
I can understand, Your Honor. Thank you.
Nice try, though. Oh, boy. Probable cause conference, April 10th, 2025, 9 a.m. Yes, that's the bond.
Your Honor, so Ms. Boss, as the court is likely aware of the nature of the case, has a longstanding history with, I think, multiple substances, including alcohol. One of these is an OWY case. I think it's her. As one of these counts relates to
No, I don't have an OWI.
is it? I'm sorry. One of these counts relates to the removal of a scram tether for such a case. I am inquiring if she is currently on an order. I saw that when she was arraigned on these cases, that I didn't see a community corrections order for her. So given the nature, I think, of the charge, I want to make sure she says it.
Ma'am, are you on a scram tether?
I was on a scram tether, and I had, a long time ago, and something I thought it was in the cases with what we are going through now. It was a part of the bond, too. I bonded out on the cases.
Okay, but are you on a scram tether right now?
No, I'm not on any kind of tether.
I believe that is correct, Your Honor, that she is not on a scram tether or on the order to be on a scram tether. My understanding.
Okay, so how does somebody get out for tampering with the device and then not get put back on the device if that were?
So that was on.
I'm sorry for being too logical. Yeah, go ahead.
So that was for another case that she was on probation for and serving for. Then allegedly something happened with that scram tether, which then the charge initiated. She has been on bond in both these cases for some time, previously referred for competency, was at the forensic center. It's found incompetent but restorable, has been restored. It's now a finding of competency. That being said, I don't believe she was ever under any order in either of these cases, to my knowledge, to be on a scram tether. And none of the charges in either of these cases are an OWI.
So, but
that don't make sense. I did a year in the county jail. I got my tether cut off, And then I did 365 days, turned around, did another 6 months. And then they pulled up charges on me for tampering with my tampering device. But me and my lawyer and the safe house with the other judge, I think it was non-prejudice to come back at me with the tether tampering. So all of a sudden,
I
they
see.
just
Okay. I got it. I'm not gonna change anything. I'm just gonna leave it where it is. Because I see the dates and so Bob will continue.
Thank you, Your Honor.
what was the date, Your Honor?
Yes, ma'am.
What was the date again? April what? 9th
10th.
or 10th?
April
At 9
10th,
o'clock.
2 weeks from today.
Okay, thank you, sir.
Thank
Thank
you.
you, Your Honor.
Thank you, Your Honor. Thank you, Ms. Boss. We'll be in touch again.
Okay, thank you.
Court calls the cases of the People versus Elijah Craft.
And on behalf of the people, Your Honor. Morning, Your Honor. Lord Daddy, public defender with on behalf of Mr. Kraft, who is approaching. Oh, oh my gosh.
I know, every week.
Every week.
I know.
In both matters. Mr. Kraft, could you state your name to the board?
What are we doing?
Your Honor, we have discovery in one matter, but not in the second matter. So the case that is ending in 0342, we have media discovery that's missing with reference to the police report. I'm hoping that the APA can make an update about that. Your Honor, we do have a media notice in the file, so I'll get that filed over today.
I'll grant the adjournment. You wanted the adjournment in both cases.
I do, Your Honor.
All right.
If the court would give it to me, I do want to address bond though. So the bond issue may impact the my request as to when the next court date should be.
So depending on what I do on bond, depends on what she's going to ask for. However, having no bearing on what I'm going to give.
Yes, Your Honor.
Why is everybody trying to trick me today? Go ahead.
Thank you, Your Honor. So Mr. Kraft has been in jail since March 14th. He was arraigned on the first case on March 16th. And the second case, he was arraigned on March 20th. Now, the bond form stated that he was on bond when the second case arose, but that's actually not accurate because it was a delayed authorization. So he has been in jail since March 14th. He's not been released, correct? And so the first case, he was arraigned on the 16th. The second case, he wasn't arraigned until the 20th, but the alleged offense date back to March 11th. I do want to note that both of the individual girls in these cases are girls that Mr. Kraft has had prior relationships with, one of whom is his child's mother, and another is ex-girlfriend. I do want to note that in the case ending in 0324, he is charged with multiple charges, including larcenies of firearms, but the police report verifies those firearms were not actually registered to the complaining witness, Dacia. She was not actually the owner of the firearms, even though he is charged with theft of her firearms. So that is, I think, a huge issue. The other issue I wanted to bring up is he is charged with 2 counts of misdemeanor domestic violence, not felonious assault in that case, one of which is for an alleged threat, and one of which is for an alleged battery, and then, of course, the resisting and obstructing. I do want to note that the very first thing in the police report regarding the complaining witness's statement is an accusation of Elijah messaging his ex-girlfriend, and I think that's what his case is clearly about in terms of the jealousy, in terms of Mr. Kraft's relationships with both women, and specifically the messages that day. I do want to note Mr. Kraft is a Marine Corps veteran who has been deployed twice to serve our country in Afghanistan. He has no criminal history, no convictions. His mother, Ms. Sonia Kraft, is here to support him. She has verified that he can stay with her in Southfield. She works from home. She'd be able to give him transportation to court. He could be on a tether if that would provide further assurance. Again, he's had no bond violations because he's been in jail since. And his stepfather is here as well to support him. So I would ask if this court would reduce its bond, specifically in the 0324 case, given all of those updates, which I think are relatively new since his arraignment.
Response.
Your Honor, people object to any modification of bond. In the first case, the defendant was at one of the victim's friend's house. An argument began. He went to a back room, was heard racking a gun, came back, pointed the gun at the victim while she was holding her infant daughter, and he then removed the magazine and proved to her that the gun was loaded. This was captured on an audio recording, their argument, and in the audio recording, it stated that he could be heard saying, if the police show up, I'm shooting her in the head. And then in the other case, it was another argument between him and a different victim, his girlfriend. He grabbed her arm, pulled her into a different room, the argument continued, and he told her, if you keep raising your voice, I'm gonna slap the shit out of you. He then slammed her onto a bed and was kneeling over her and said if she hit him, he would F her up. And then in that case, she had 3 missing pistols and they were found in his car in a suitcase. I have extreme concerns for not only the victim in the domestic violence case safety, but the other person's safety in the other case, who was just a friend. He pointed a gun at while she was holding her child. He does have a previous dismissed unlawful imprisonment FA and DV with the same victim on the DV case that was dismissed because she failed to appear. However, she is on board in this case. And I have extreme concerns for their safety given the allegations.
Anything else?
Your Honor, I just want to note that Mr. Kraft does adamantly deny the allegations. He has consistently been asking for a polygraph. We do have a potential witness who we are investigating further, but as to the main witness's credibility in terms of admitting that she didn't tell completely the truth about the allegations, obviously he is proven innocent of the allegations at this stage. Obviously, they are very concerning allegations, but the question is, are there bond conditions that can be set to ensure her safety as well as the community safety pending trial in this case? And I would argue there are conditions. So a GPS tether, no contact, which again, he's had he's given the court no reason to believe, and sorry, let me rephrase. He's given the court every reason to believe that he can and would abide by a no contact order. I mean, he's a Marine Corps veteran. He knows the rules. He knows how to follow them. And a GPS tether, no contact order.
And also how to handle a firearm and never pointed at anybody.
Yes, Your Honor.
Okay, just checking.
Yeah.
Go ahead.
So we would ask for a reduction bond.
Motion for bond reduction is denied. I will, however, set his probable cause conference out to April 3rd rather than 2 weeks.
Thank you, Your Honor.
Bond will continue. Thank you. For calls case, People versus Desmond Burton.
Jim Kennedy, absentee, for Your Honor.
Public Defender Chelsea Whitfield, on behalf of Desmond Burton, approaches. Mr. Burton, please state your name to the record.
Yes, I've heard.
We're asking for an adjournment for discovery and a plea session.
Probable cause conference, April 17th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you.
Court does call the case People versus Gregory Davis. Smith Yagi's case.
I apologize, Your Honor. Lori Yagi, Assistant Public Defender, with me on behalf of Mr. Davis, who is standing to my right.
Your name, sir? Thank you.
So there's a couple, well, I think the main issue here, Your Honor, is missing discovery. I would ask for an adjournment in order to obtain via discovery that's referenced in this report.
How soon can they get that?
I'm sorry.
There's discovery that's needed.
We sent everything. I think the issue is the chair just hasn't had an opportunity to review it. Is that correct?
That is not, I do not see,
Okay.
unless it was within, was it this morning that it was sent?
No,
Was it as of yesterday? I did not have the surveillance video, the 911 call, and you said it would take a while to get time.
911 call will take a day or two to come in. I think the video should have been provided to you yesterday. So we will follow up.
April 10th, 2025, 9 a.m. Bond continued. Court calls case, People versus Kristen Bird.
Good morning, Your Honor.
Good morning.
Sorry, my camera's a little blurred.
It's okay. We got you. All right.
Assistant Public Defender Dan Wood with on behalf of Mr. Bird is presently assumed. Sir, can you please state your name for the record?
Christian Bird.
Thank you, Your Honor. I'm respectfully requesting a very brief adjournment. I want to discuss this matter with people. I do not believe I have a good phone number for Mr. Bird, however. So, Mr. Bird, can you please call the Public Defender's office or email me back so we can talk? And then we will talk for the next court hearing.
Ma'am, I did receive your phone call. I just wasn't able to call you back. I can call you today, though.
Perfect.
April 17th, 2025, 9 a.m.
All right, thank you.
Thank you. Court calls case, People versus Portia Elledge.
Assistant Public Defender Ben Dunn on behalf of Mr. Elledge, who is entering the courtroom now. Portia, would you please state your name for the record?
Yes, Portia Elledge.
Thank you.
Your Honor, the defense is going to demand exam.
It just asked. All discovery complete.
Yes.
People have their witnesses available the 8th. Preliminary examination in person, April 8th, 2025, 9 a.m. That's before Judge Valvo.
Thank you, Judge.
Thank you. Bond continued. Court does call the case, People versus Robert Connolly.
Thank you, Sarah. Yeah.
Hi, Matt, can you please approach to my right? Please state your name for the record.
Okay, you're requesting an adjournment?
Yes, we are still waiting for one second.
Without objection, probable cause, April 17th, 2025, 9 a.m. Bond continued. Thank you.
Thank you, Your Honor.
Court calls case, People versus, is it Alua Gillis?
And is that on behalf of the people, Your Honor?
Yeah, the Assistant Public Defender on behalf of Ms. Gillis, she is incarcerated.
They don't have Gillis. Hold on a second. Who do they have?
They should have Lamar Jones.
Court calls case, People versus Lamar Jones. Is that who they have?
And is that on behalf of the people, Your Honor?
Good morning, Your Honor. Alice Warren, Reno, Mr. Jones.
Mr. This one.
Lamar Jones.
This. Go ahead.
Your Honor, today's date and time for probable cause conference execution reached the resolution. We're asking the court to consider the contest pleas to count 5 and count 6 on the complaint. In exchange, the people have agreed to dismiss the 4 remaining counts and have consented to sentencing.
That's correct, Your Honor.
So the assault and battery and the domestic violence charge and dismissing the other 4 counts. Is that what we're doing?
Correct.
Raise your right hand. Do you solemnly swear in front of the testimony about to give the truth, the whole truth, and nothing but the truth, so help you? Yes. Say your name. Lamar Jones.
Sir, it is this court's understanding that you're going to be pleading no contest to 2 charges. Is that correct?
Yes, sir.
First charge is that of assault and or assault and battery. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes, sir.
The other charge is stated count 6 is a charge of domestic violence. That's also a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes, sir.
Do you understand also, do you understand what a no contest plea is? 2 things about it I have to make sure that you understand. The first thing you need to understand about a no contest plea is it means that you're not further desirous or wanting to contest these charges. You understand that? Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Sir.
You understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
Basis of the no contest plea.
Lack of recollection, Your Honor.
Sir, to the charge of assault and battery, how do you plead? To the charge of domestic violence, how do you plead? You understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form. Any question regarding any of those rights?
Yes, sir.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal over it.
Yes, sir.
Are you on probation or parole?
Fine. No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 259016. Any objection to the court having reviewed that report? Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court rule?
Yes, Your Honor.
Not satisfied.
Court will accept the defendant's pleas of no contest to counts 5 and 6. Counts 1 through 4 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be April 21st, 2025, 10 a.m. before Judge Washington. Bond will continue.
Your Honor, may I
Briefly.
Thank you, Your Honor. Last time Mr. Jones was remanded on a positive ETG test. Prior to that, he returned 2 negative ETG tests, and at the time he returned that positive ETG test, he was referred to community correctional outpatient. My understanding is he was forthright about that failed test. The supervision agent with the court, this is his first interaction with the criminal justice system. I think after the court reviewed the police report, the court would know that this case is really about intoxication. With the people agreeing that 4A, we're just asking, we're asking the court to consider reinstating his bond so that he can kind of show that he's a good candidate for that.
Ms. Rounds.
Your Honor, we'll leave it at discretion of the court.
Well, how am I going to stop him from drinking?
Your Honor, I think he's going to...
Because that's where all the problems flow.
Won't be honest.
You kind of said that to us before, right? You really never said that? So when we told you no alcohol, you thought it was going to be an issue?
No, he said it won't be an issue. I can guarantee you that.
Your Honor, if the court considers our request, I think Mr. Jones will immediately do something to treat. I think that he needs that and some kind of support group. Either whereas I know that the drinking incident this time, my client tells me it was prompted by him being separated from his family support system. If he were released from custody, he could be relieved from the complaining innocence matter, staying with his sister. She's responsible for unity. She works at she'll keep it on him and ensure he's not drinking or buying.
reinstate his previous bond conditions. But he's to report to community corrections for placement on a scram town. I need an order.
Prior to.
Yes. Thank you.
Thank you.
Court calls case, People versus Nicholas Coots.
The attorney appearing on behalf of the people.
Assistant Public Defender Chelsea Reveals on behalf of Nicholas Cruz. Your Honor, I have contact with Mr. Gates. Was going to ask you here at the probable cause conference for discovery purposes.
Yeah, consider it now. Bench warrant will issue for defendant's failure to appear. Bond 10,000. Cash surety. Yeah, well, actually, I'm going to make it 25,000 cash surety. He has a community corrections violation. Also, that warrant will issue immediately. Thank you. Court calls case of the People versus William Jones.
The public defender, Ben
He's got to keep moving. Keep moving.
Mr. Jones, would you please state your name for the record? William Jones. Your Honor, my understanding from Mr. Jones' family that is present is that he's going to retain counsel, so we would ask the court for a 1-week adjournment so that he can do that.
April 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Court calls case People versus Antonio Cornelius.
The attorney appearing on behalf of the people.
Yes, this is public defender, with Mr. Cornelius, and Christian Podium.
Can you take your name to the court?
Your Honor, this is a case where we have obstructed justice. And so I would ask for a 2-week adjournment. I am hopeful that we can get the process started and or
Whatever that is. Yes.
No objection.
April 10th, 2025, 9 a.m. Bond continued.
Thank you.
Court calls case of the People versus Alua Gillis.
And then on behalf of the people, Your Honor.
And Lori Yagi, Assistant Public Defender, with on behalf of
Ms. Gillis, can you state your name for the court? Ms. Gillis?
Thank you.
Your Honor, I do believe discovery is complete in this case. We're asking that it be back to preliminary.
People have their witnesses available the 8th.
Do our best, Your Honor.
Preliminary examination will be set April 8th, 2025, 9 a.m. in person before Judge Barr. Bond will continue. Court calls case of the People versus Sean Cotton.
Assistant Public Defender Chelsea Reveals with on behalf of Sean Cotton. Here is you, Mr. Cotton. Please state your name. I think you need to unmute, Mr. Cotton.
Sean Cotton.
We're asking to adjourn to work out some restitution issues in this case.
Probable cause conference April 17th, 2025, 9 a.m. Bond continues.
Thank you.
Thank you. Court calls case People versus Glenn Page.
Public defender, prosecution. To my right.
Thank you.
Urges indicate date, time, etc.
respectfully request to be sent this to the preliminary exam.
All discovery is complete. People have their witnesses available the 8th.
I'll set the prayer.
Preliminary examination in person, April 8th, 2025, 9 a.m. That's before Judge Valvo. Briefly.
Mr. Chairman, my client's going to be asking for our bond in this case. This incident 5 years ago. He's already spent 13 days in jail. He's a lifelong resident of Queensland. He lives here locally at the Huron Heights. So he's not in this Section 8 housing. He's got a job waiting for him at the Bellflower restaurant. We just have to give it a PR bond. I know he has another bond at 2. He's hoping to come to a resolution of that case.
So he's being held on another matter? He failed to appear on this matter, which is why he has the one that he has.
Not properly.
Notice was not properly received. What's that mean?
I don't think that he was prepared exactly for the time.
So he wasn't told? Is that what he wants to relate to me? But he wasn't told when his court date was? He wasn't told when his court date was?
He was told, so I'm not sure.
Your Honor?
Yes.
I'll just add for the record that I actually arraigned Mr. Page on this case, and on November 17th of 2023, where he was arraigned for previously failing to appear for 2 days on this matter. So I can appreciate that he might not have gotten notice prior to that, but he certainly knew then he was in custody given that date. But he also
That's what I was getting at. He was told the court date. And he didn't appear. Motion for bond reduction denied. Bond will continue. Thank you. Court calls case, People versus Thomas Lee Ellis. Is he on a tether or sober now? What was the alleged VAC in this matter?
this case, it looks like it was 0.13.
With priors. Hey, community corrections, all right. What did you want to do on this case? Probable cause conference will be adjourned April 17th, 2025, 9 a.m. Or as your invite indicates, this bond will continue with the added condition defendants to report to the Department of Community Corrections for placement on a scram tether. Okay, that's what I was asking. He's on testing. You already have one. Yeah, that's what I thought. Okay. Thank you. Courthouse case, People versus Jacob Potter. Yeah. Is that who they have?
Right.
Take a valid kind of product.
Thank you.
This time we're being respectfully requesting the sentence for a preliminary exam.
All discovery is complete.
My knowledge.
People have their witnesses available the 8th.
Do our best, Your Honor.
Preliminary examination in person, April 8th, 2025, 9 a.m. That's before Judge.
Address bond briefly.
You may.
My client is going to be asking for a PR bond
has a place in Belleville where he's getting ready to be staying with a friend over on Rustic Drive. He's going to want to tether if the court deems that necessary. He just wants to get back to his job. He works at public disposal. 50 hours a week there. He wants to get back to his job. So
Yes.
Your Honor, I'm also going to ask the court to address bond, as he has made 52 calls to the victim from his pen since arraignment. In these calls, he says, "You gotta go to the prosecutor's office and tell them it's not written down right, that I live there too. I damaged the door, they're making it look like I just entered the place, I've never been there before, and that I'm your ex-boyfriend." He also says, "Go to the prosecutor's office and speak on our behalf, whatever, I can't talk to you." He also says, "This is a serious issue, I don't know if you can help, I don't know if the prosecutor tomorrow or anything, I don't know. You need to leave your number out, anything you may sign, you know what I mean, if you, or the prosecutor or anything, leave your phone number out of anything that you might sign, that way they can't link due to my call history." And then he also asks her to get on the Text Now app they have in the jail, because we can't see that, and that's how he wants to keep communicating with her. So I have extreme concerns that he can't follow court orders and object to any modification.
I understand your right. We spoke to him. That needs no contact period. He just wanted to somehow give information to the court that he lives at the address. Question. But
He wanted to get that communicated to the person that does live at the address? That makes no sense.
I will just add that when he was at the address, he kicked the door open and entered the house without permission, and he began throwing her items against the wall and was intoxicated. So I have extreme concerns that the people going in here like that.
Defendant's phone privileges are revoked. Defendant's motion for bond reduction is denied. Bond will continue, but his privileges are revoked. Thank you. Calls the case, People versus Sadie Padro, or Padro.
And then I'm happy, Your Honor.
And that was Warren doing on behalf of Ms. Fadro.
Well, thank you.
Your Honor, maybe briefly approach.
Okay, record to reflect, we've had a bench conference in this case. So, you retain counsel, so they'll be appearing at the next.
That's correct, Your Honor. I spoke with Attorney Joe Hall yesterday. He just asked me to kind of stay today, but I believe that designed a substitution to be filed.
All right. Probable cause conference under those circumstances will be adjourned to the 10th, 9 a.m. or as your invite indicates. Ma'am, how'd you get here?
My mother.
And did you come just with your brother?
My mother. I just came with my mother, yes.
Only people in the vehicle?
Yes.
Okay, I want to admonish you because I noticed that you are within feet of the alleged victim in this case. You can't be near them. Understood?
Understood.
And because you're the one under the jurisdiction of the court, it's on you. So they can sit down and you just got to get up and try to move yourself away. Am I clear? With that admonishment, bond will continue. Thank you.
Yeah.
Court calls the case, People versus Scott Reese.
Sophia Curry, here to be on the people. Stephanie, on behalf of Mr. Reese. Mr. Reese, when you're at the lectern, please state your name for the record.
Scott William Reese.
Thank you, sir.
Your Honor, I did file a motion sheet in this case. We're going to ask for a 1-week adjournment. I've asked for some additional discovery, which includes 911 state proof of ownership of where he is alleged to have broken into. My client.
Are they going to be able to get that to you in a week? I mean, I don't have a problem adjourning in a week, but they're gonna.
Probably not the 911 call. I have requested those items, but I'm not sure. I can request, I believe, yesterday. But I don't think we'll have the 911 call.
But you'll have everything else in a week, and are you gonna need the 911 call?
Your Honor, it's alleged that they specifically identified my client in that call, so I wanted to see whether or not that was accurate.
Well, I got you. So it seems that that's rather relevant. I'm gonna go 2 weeks out just because I want to make sure it's here. You were going to anyway, so go ahead.
So my client does have a defense in this case regarding the ownership of that particular property. It's my belief that once everything is pulled together, it's going to show that he had every right to be there. He was paying rent on the property. He was basically subleasing from someone. And then the police just bust in and took him. So in the report, it even indicates we're trying to figure out who owns it. Well, I think that's important before you bust in and arrest somebody to figure out who owns the property. And so my client.
Really?
Sorry, Robert.
No, I'm just.
So I
that was very dramatic.
It is.
In terms of how you said that.
You can see the condition of my client, where he believes I believe that he's lawfully present. So we're just asking that he be released. I mean, the address is his address, as is the one next to it.
Well, okay, so here's going to be the problem.
Yes,
if I were to release him, he would go to that address, which at this point, I don't have anything. I mean, I hear what you're saying, but I don't have anything to say. It seems to me that there would be written documentation about what you're saying.
So I've asked for it, and I'm doing an investigation request, but before the police go in, I do believe they also should understand.
Well, if you want to blame the police, I mean, they're gonna get their call, and they're gonna have to respond to the call. But counsel approach. Record should reflect we've had a bench conference in this case, and there's obviously something that's going to have to be looked at. I'm going to set this for the 10th. The motion for any reduction in bond or change in his bond, I'm going to deny at this time.
Thank you.
All right. Thank you. Court calls the case, People versus Justin Fowler.
And then on behalf of people. And I think we have Mr. Fowler, right?
Justin Fowler.
All right, what are we doing? I do have a plea form. Plea form indicates that the defendant would be pleading to count 3, which is MDOP, malicious destruction of personal property less than 200 in a domestic relationship, as well as domestic violence, second offense, the 1 year. That's the added count 4. Upon a successful no contest plea to those charges, counts 1 and 2 would be dismissed. There's also an agreement, although the court can't bind the sentencing judge to go up from jail, but there is an agreement to pay full restitution. I'm assuming on all counts.
That's correct.
Sure.
Let's have him sworn.
So I'm just want to confirm testimony about the Justin Fowler.
All right, so it is this court's understanding that you are going to be pleading guilty or pleading no contest to 2 charges. Is that correct? The first is a stated count 3 of malicious destruction of personal property less than $200 involving a domestic relationship. That is a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court costs. Fine could be increased 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. Do you understand that, sir? All right. You're also pleading no contest to the charge of domestic violence, second offense. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. You understand that? Do you understand what a no contest plea is? 2 things about it I have to make sure that you understand. It first of all means that you're not desirous or wanting to contest these 2 charges. You understand that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty to these charges. You understand that? You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. All right. Basis for the no contest plea, counsel. So, sir, to the charge of malicious destruction of personal property, less than $200, how do you plead? To the charge of domestic violence, second offense, how do you plead? Now, you understand that by pleading no contest, you will not have a trial of any kind. You signed an advice of rights form, is that correct? Any question regarding any of those rights? Please look at paragraph 5. Those are the rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on them. You understand you're giving up your right to appeal of right. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plea? Anybody threaten you or coerce you? You're doing this voluntarily and of your own free will. Court has been provided and has reviewed Washtenaw County Sheriff's Office report for their case number 25-13754. Any objection to the court having reviewed that report?
Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's no contest pleas to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
April 28th at 10 a.m. Judge Washington.
April 28, 2025, 10 a.m. before Judge Washington. They'll do that. No, you're good. Bond will continue. He's out.
Modification. Commission.
Oh, you want me? Oh. I read it.
Work and travel level, so I was just asking if this court for function assignment.
Response on the people.
You're not looking for description. I'm just asking if you change them to a hot zone.
What is it? Is his current tether home confinement?
It's got a hot,
Pardon?
got a hot zone on it. And it's,
It should have a hot zone, but pardon?
I'm home to work.
So if he can go to work, what are you
He
asking?
has to travel for work in 6 weeks.
To where? Gaylord. You don't even know where that is, do you? You said it like it was a strange city. It's like He has never been to Gaylord, Michigan. Because it's pronounced Gaylord, not. It's not two separate words. No, it's okay. We're in Michigan. She's gonna talk about Florida. So, I guess the thing is, if under the current order, I don't know if I need to amend it, because under the current order, if he shows proof that he's supposed to be someplace else for employment, he should be able to go.
so what? Can I speak?
Sure.
All right. So
As long as you say Gaylord, not Gaylord. Anyway, go.
Travel, do infrastructure repair. And, like, the times that I have had to leave in Saginaw, when they give you extended hours out for those days, like, my earliest time I think I could have left my house was 5 in the morning.
They extended your time for you to be able to get there and back.
Exactly. So, like, it's 4 hours to get there from my house.
I knew that. She didn't.
Well,
Go ahead.
So, for me to get here all the way to
No, I hear you. So here's what you need to do. Get an indication, or I probably prefer to do it this way. get some proof from your employer that you're to be there.
Your Honor,
Get it?
I believe what Mr. College trying to say is he travels even more than just Taylor, Michigan. He goes to other places, and it would be a burden for him to always have to, because he doesn't know where he's going as a construction worker, and he kind of gets the job on the spot. So I think he's just asking.
Here's what I'll do. I mean, I get it. I get that. But he's going, who is that? I lost my train of thought. That was such beautiful music. I almost went to sleep. So, when are you going to Galen?
It's not, I don't have it set in stone yet. It's, I think they have it scheduled for like the middle of April, but I understand, but it's not set in stone yet. Depends on a lot of variables up there. County. So that's kind of why I just wanted to see if I can have the GPS locator, but it's not a problem.
Okay, I'll sign an order indicating that as long as defendant provides proof of his that he's got employment somewhere, defendant may travel to that location.
So every time he wants to do somewhere,
No, what I'm saying, well, he would have to provide proof to community corrections for his tether purposes, but he doesn't have to come to the court every time. So that, because I get what he's saying, it's going to depend sometimes on what other people are doing, and then all of a sudden next thing we're called up to go. Get that idea. So what you would need to do, I'm going to give that order that you can go and do it. So they don't have to do extended hours. You'll be able to go. You just have to provide proof to community corrections that you have them, that you are supposed to be there from your employer.
Are you okay to like stay in Gaylord for?
From my standpoint, yes, because you'd be working up there.
Right, it's not like I'm just on vacation.
In Gaylord, yeah, okay. So, no offense to anyone that lives there, but I'm just saying. So, yeah, my intent, so that we're clear, my intent is to be able to allow you to go work. If you're someplace, why don't you just put this in the order? That if it's over 2 hours travel time, defendant may stay in that location. Okay, put that in the order. That way he doesn't have to worry about that. Okay?
Yeah.
You're welcome.
Regular, like, in and out times to be back home, except for when I'm going out of town. That's kind of.
What? Are you trying to make this more complicated? I'm just.
Your Honor, I think my point is trying to set, does he still have to have a set time and date every time he needs to go to inform probation, or can he just,
I don't know. No, what I'm saying is, it seems to me they allow him to go to work, right? And so they have the hours for that. That's what he'd have to abide by. But I get that there are times that he's, the whole notion of going to Saginaw and then having to come back and extend the hours, seems a bit much. It's going to certainly seem a bit much for travel to Galen. Right, but in the interim between now and sentencing, where Judge Washington can address it, I'm trying to set something in place that makes it a little bit easier. I'm not taking all of the guardrails off. I'm making it a little bit easier for him to be able to work. Okay.
I appreciate that. Like I said, I don't have a problem. It's just the home confinement part, moving around, trying to get to work.
I get you, but there's a reason why that's in place, but we're kind of loosening the parameters of that and allow you to work. Okay, do you think, Ms. Mackey, you could prepare that order? No, we'll wait and we'll see what it says. Probably have to send it back, and next thing I know, I gotta remember, review the transcript, it's gonna be a mess. All right, thank you. See that over there. Court calls the case, People versus Clarence Tomita.
Good morning, Your Honor. Jacob Canada, on behalf of the people.
The public defender, Brenda, on behalf of Mr. Vita, who is now entering the courtroom. This way. Mr. Tomato, would you please state your name for the record? Did the court hear that?
Yeah, I do.
Your Honor, the defense would like to demand exam and we would like to address bond if it's okay with the court.
Discovery is complete.
We have one outstanding video, but the prosecutor has it, just had to agree on the protective order, which we have done, so that's coming.
The protective order studies be sent to the court staff, released by our office to defense counsel. So discovery is not being this time.
Hey, but have you signed off on the order?
I'm going to send it to you now.
Okay. And then you're going to be able to view whatever it is, but then, all right. Would your witnesses, I really don't consider that complete, but. People have their witnesses available to 15.
Yes, Your Honor.
I'll set a preliminary examination in person April 15th, 2025, 9 a.m. Is that before Judge Moore? Before Judge Moore. As to bond.
As the bond, Your Honor, bond is currently $100,000 cash. This is a 4-year delay for the case. There has never been a similar allegation in the past. So I'd argue to the court, he can be tethered to his mother's house and would like to get out to care for his elderly mother. The court could have set other hours of that was necessary. I'm sure the court would order no contact with minors during the pendency of this case. I do believe those conditions would be sufficient to protect the community. Mr. Richmond has lived in the area his whole life. He's here with his elderly mother, so we don't believe he's a flight risk either. And we'd ask for personal recognizance bond.
Respond.
Your Honor, this is a case concerning from such a conduct second degree of a minor case. This accused of assaulting the minor for a period of 6 years between the ages of 4 and 10. During that time, the victim was assured for her breast, touched between the thighs, kissed her on the mouth. Additionally, Your Honor, when deputies went to ask the defendant about these allegations, he told them as they were getting ready to leave, asked them actually if they could go shoot them. Stated that he would not, the deputies stated they would not. Then the defendant started laughing and said, "I'm serious, man, this is fucking bullshit." So I have grave concern. That was the victim and the community. And I would actually ask the defendant to bond the rates.
Your Honor, I think my client, essentially pleading not guilty to at least using colorful language should not be held against him. He certainly maintains his innocence. We'd ask for PR bond.
Motion for bond reduction is denied. I'm not going to raise it either at this point, but motion for bond reduction is denied.
Thank you.
Court calls the case of the People versus Eric Fowler. Thank you. Did you and Bellinger coordinate suits? No, I'm just asking. Go ahead, Mr. Brown.
So that we have approached the prosecution concerning this resolution. I believe that we have to speak
with the officer.
The officer.
That's correct, Your Honor. I actually sent an email before the docket got started in the hopes that I might hear back by the time the case was called. I have not gotten a response yet. So I think we may be able to resolve, but if counsel is requesting an adjournment, I will.
So you have two options. If you want us to move the case forward, instead of that's fine. Or, based on what you're told today, you can adjourn.
Why don't I adjourn it out to 10? And let's see what they say, because that's going to sort of dictate which client they want to do on this. April 10th, 2025, 9 a.m. or as your invite indicates. Bond will continue. Thank you.
Thank you.
Thank you, sir. Court calls case People versus Christopher Garrett. No, I was calling another case.
Good afternoon, or good morning. It's not quite afternoon yet. Good morning again, Your Honor. Victoria Burton here as Chief Assistant Prosecutor appearing again on behalf of the people. Go ahead, Ben.
Sorry, Ben, I don't know if we have Mr. Garrett, you're standing to my right. This is what Garrett. Thank you.
All right, what are we doing?
Your Honor, our office will be dismissing this matter.
Any objection?
No.
All right, case is dismissed. Okay, thank you.
Thank you.
Court calls case People versus Floyd Green.
And this is on behalf of the people, Your Honor.
And Alex Miller Green on behalf of Mr. Green, constituent Floyd Green. Your Honor, today's date and time for probable cause conference, we are asking for the subject matter for preliminary.
What's going on out there? Discovery is complete then.
Yes, sir, Your Honor.
People have their witnesses available the 8th. Preliminary examination in person, April 8th, 2025, 9 a.m. before Judge Valvo. Bound continued. Thank you, sir. Court calls case People versus Amanda Grove. She's on.
Sister Defender Natalie Paper on behalf of Ms. Grove, is present via Zoom. May I please unmute and state your name to the court?
Amanda Grove.
Thank you.
And the children's parent, yeah.
Thank you, Your Honor. I have discussed this matter with both Mr. Childers and my client. At this time, I wish to set the case for preliminary examination.
Discovery is complete. People have their witnesses available the 8th. Preliminary examination in person, April 8th, 2025, 9 a.m. That's before Judge Barr. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case of the People versus Muriel Hearn.
Assistant Public Defender Jay Goins on behalf of
All right. Hey, you're requesting an adjournment.
Yes, Your Honor.
Probable cause conference will be adjourned without objection, April 17th, 2025, 9 a.m. Bond will continue. Thank you. Court calls case People versus Victor Jefferson.
Get rid of the people.
Why is she walking across my floor? Yeah.
So I'm sorry.
Victor Jefferson?
Thank you so much. I apologize. Assistant Public Defender Jay Goins on behalf of Mr. Jefferson is not present today, Your Honor. Last time we were in court, we advised that he would not have to be present before submitting health files.
That is the correct statement, Your Honor, and
You're going to dismiss it. Case is dismissed.
Thank you.
Court calls case People versus Quincy Jones.
My assistant public defender on behalf of Mr. Jones. Say your full name, please. Your Honor, we are requesting an adjournment today. I have been told that the people are reviewing a new warrant request, charges, and we just want to adjourn. So the charges weren't put together.
Yeah. How much time would we be?
Your Honor, so the warrant was submitted March 18th. I'll go ahead and assign that warrant to myself to get that reviewed before our minutes.
All right. So why don't I adjourn this one out to April 17th? Let's see how that works. 9 a.m. Bond continued. Thank you. Court calls the case People versus Maxwell Lawson.
Victoria Burton here, Chief Assistant Prosecutor, appearing on behalf of the people.
I got the signal, Ballinger. Go ahead.
Lord, yeah, you public better with yeah, Mr. Lawson, standing to my right. You state your name to the court.
Thank you, sir.
Your Honor, I am optimistic and hopeful that we're going to come to a resolution in this, but I believe sobriety court and recovery court would be in Mr. Lawson's best interest. He is not a Washington County resident, so I've been trying to follow up with 2 different programs in Wayne County. I don't have an update yet, so I am asking.
I'll grant an adjournment.
Thank you.
Probable cause conference will be adjourned April 17th. Let's see where we are at that point. 2025, 9 a.m. Bond continued.
And thank you, Your Honor. I just want to put on the record, and I don't believe Ms. Burton Harris extended an offer, and she indicated that it would remain open until the next date as well.
That is correct, Your Honor.
Thank you.
Thank you.
Court calls case People versus Tyler Pittman.
And Lord Yakis, Deputy Public Defender, with and on behalf of Mr. Pittman, standing to my right, Mr. Pittman, state your name for the court.
I'll adjourn, you're requesting an adjournment, I'll adjourn it.
Thank you.
April 17th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, sir. Calls the case People versus Larry Hickman. All these people are at their jail. Okay, he's not here. He's at the hospital. I'll grant the request for an adjournment. I'll adjourn April 17th, and we'll see where we are. 2025, 9 a.m. Bond continued. Refusing. Court calls the case People versus Cody Jolly. He has no counsel. In this case, Mr. Jolly is once again refusing to come up. So, since he's refusing, not sure what we're ultimately going to do, but I'll just...
We're trying to petition.
Got it. Okay. April 24th, 2025, 9 a.m. Bond will continue. Court calls case of the People versus Ryan Piper. He is refusing to come up.
Yes, yeah. It's the court of receipt of a report dated March 10th, 2025.
I am.
Yes, it's up from my understanding that Mr. Nicholas has been found still incompetent to stand trial and likely to be competence. This
Right.
found that Andrea L. Vandenberg, he was stipulated to the findings of the
Are you going to be able to stipulate without your client present? Yeah. I'll adjourn this out to the 17th. You can figure out how you're going to try to accomplish that.
maybe
Yeah, Bond continued. Court calls case the People versus Shaquille O'Neal Cubs.
a total failure this is. Do that. Good morning. Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
Proceed. Gentlemen?
Assistant Public Defender, but that one on behalf of Mr. Poe. And Your Honor, I understand from the deputies that my client did not want to be present today.
Yeah.
So
He does that occasionally.
when I spoke to him, he was looking forward to being present. So I guess I would just leave it to the board's discretion.
I'll adjourn it out to the 17th. He'll change his mind after a while, maybe. But we'll continue.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Javon Mills.
And I was wondering about Mr. Mills, Your Honor, he's in the hallway. I can do it. Thank you.
Oh, somebody do it. Or is he in the hallway?
Always.
Yeah, right. That's a good point. Okay.
Your Honor, today's date and time for probable cause conference. I've spoken to people about receiving media discovery. I believe that is in transmission. I have an adjournment request for here. I also have a stipulation posed in order for the court to consider relative to changing its GPS tether conditions. Mr. Mills wishes to attend the computer from this Friday, his visitation, and this Saturday.
Okay, so, you know, and you stipulated to that.
I have the written stipulation.
That's correct, Your Honor.
All right. Oh, Detroit. Okay.
And Your Honor, I need the times blank on that proposed order, so I just asked Mr. Thompson if he could provide an idea of specific.
Well, go ahead.
So, obviously, the visitation is more what time would be, they would need to come out of the house and return to the house.
Well, hold on a moment before you answer that. The visitation's from 3 to 8 on Friday. All right. This is your brother? All right. And then the service. Okay, I gotcha. So as I look through this. All right. And then the funeral. All right. I don't. All right, why don't we do this? I'm going to hand the order back to you. Have a conversation with Mr. Mills regarding that. My posture on it is on the visitation that it's going to, you live in Ipsy. All right. So on the visitation, my posture is going to be an hour on either side of that visitation done. Okay. And I think that should do that. The more difficult part's going to be well, I'll just ask you this, Mr. Milton. The family hour is not just an hour. That's the other part. So if I did 3 hours for family hour, you think that would be able to satisfy it? Because some of it's going to depend on how big your family can be. Yeah. All right. So what I'm going to do for the family hour, though, is I'm going to do 3 hours on that. Okay. Because it starts at 5. It says at 5 p.m. is when family hour starts, right? Okay, so when I say 3 hours, here's what I'm going to do. An hour beforehand, and then 3 hours actually of family hour, and then an hour to get back. Okay. And then on the funeral, that's at 5:30. So I'll let you fill in the times, but I'm likely with the funeral. Is there going to procession to the site after the funeral? Or? Yeah, after. Okay, and that's not on here. So talk with him about that and where that's going to take place, so that I'm going to be flexible with the time frame, because I get it's not going to go. You can't. Some of the stuff you can't schedule. You don't know. Okay, so fill that out. I'm not going to have a problem with much of that if people know. Okay.
Thank you.
All right. I'll adjourn. Just 1 week? He's out of custody. I'll go out 2 weeks. I'm not gonna go out. Probable cause conference April 10th, 2025 at 9. Or as your invite indicates, bond will continue. Okay. Thank you, and sir, I'm sorry about your loss. Court calls the case People versus Robin D. Noble.
It is now afternoon, so good afternoon, Your Honor. Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
The Public Defender Natalie T. on behalf of Ms. Noble, who is not present yet. She is currently on a bus on the way to Ann Arbor.
Yes, because we have a violation and she was appeared.
Yes, and I have spoken or emailed with Ms. Bureau of the Community Corrections, who did confirm that my client does have an intake appointment scheduled at Community Corrections for 2 p.m. tomorrow. And Ms. Nobles is on her way here to court in person. I did provide the court via email with a copy of the bus ticket as well as the people. She's not set to arrive until 3:30 p.m. However, I know
3:30?
3:30 in Ann Arbor, Your Honor. Yes.
Where is she coming from?
I forget the city on the bus ticket. It's from several hours away, and she departed at 9:15. I believe it was this morning. It's either 9:15 or 9:15.
Okay.
But it's the court consider passing.
What do you want me to do? Issue a bench warrant and then recall it when she gets here at 3:30? I'll pass it.
Thank you so much, Your Honor. I appreciate it.
Court calls the case People versus Derek. Is it Venerados?
Thank you, Richard. People.
I don't know where. Venerados. Yeah. All right. What are we doing?
I'll be requesting a brief adjournment for further negotiations, approximately 2 weeks.
Do I have a sheet from it? Not objection. Probable cause conference April 17th, 2025. 9 a.m. Bond continued. Thank you. Court calls case of the People versus Aaron Piccini.
Good afternoon, Your Honor. Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
Public Defender Chelsea Fields, appearing on behalf of Aaron Piccini. Mr. Piccini, please state your name.
Aaron Piccini.
Yeah, usually when people do.
We still got the referral form that says everything 2014 report, but you're still waiting your back.
So they've not set an interview time yet or anything with them?
I don't believe so. Mr. Piccini, have you been contacted by anyone at the 14 BC?
You're muted, Mr. Piccini.
Okay, I'm already in drug court. They were just waiting for this to get sent over. They're gonna sentence it along with my current drug court.
Got it. Okay. So I'll just go out 2 weeks and see if we can get this resolved to get this case over. Okay. Probable cause conference April 10th, 2025, 9 a.m. or as your invite indicates. All right. Thank you, sir.
Thank you.
Court calls case People versus India Robinson.
Robinson, who is present in Zoom. May I please unmute, state your name for the court?
India Robinson.
Thank you, Your Honor. I have had the opportunity to review discovery with my client. At this time, we wish to set this case for preliminary examination. Discovery is complete to our knowledge.
People have their witnesses available on the 8th. Preliminary examination in 8th, 2025, 9 a.m. That is before Judge Valvo.
Your Honor, if I may, briefly address condition of filing.
Yes.
Thank you, Your Honor. So this is charges to OWI third offense, and Ms. Robinson is currently on a spring tether. To my understanding, she is completely compliant. She resides in Detroit and is not currently driving, so has to take the lift every time she appears for community corrections for her scram downloads. She states to me that it costs $50 each time she has to come to community corrections for the download. She is asking if the court would consider switching her to a SoberLink device rather than a scram tether. She understands as many times a day as the court would want her to go into that. She of course, has not been on any substances since her arraignment, or actually prior to that. To be candid, I told her that the court was unlikely to change it, but we are making that request that the court would consider switching her from scram to the SoberLink due to the cost it takes her to come here to the downloads.
Did the people have a position?
I'm sorry, Your Honor, I couldn't hear you.
Do the people have a position on the testing?
Your Honor, so I am not in position of any results with Ms. Robinson, but trusting that counsel's representation is true, I don't actually have an objection to SoberLink. Sometimes that's the preference of the individual pastor, so I believe that's the discretion of the court. I will note that the BAC.
That's what I was looking for.
77.
Yeah, that's why. I mean, part of the reason that was probably likely skipped by the setting of it is her BAC was a .277, and there are, at least as indicated here, 5 alcohol-related convictions. So, I'm not going to change that. Motion to change yours tonight.
Understood, Your Honor. Thank you. And thank you, Ms. Robinson. We'll be in touch for your next court date.
Thank you.
Court calls case People versus Cynthia Suttle.
Ms. Soto, please be via Zoom.
Ms. Suttle, I need you to turn your camera on and unmute.
Okay. I am
State your name, please.
Cynthia Suttle.
All right. What do we
Hopefully it's unmuted. I can't see you, but I'm hoping it did, but it was supposed to.
You are unmuted. We can hear you and we can actually see you.
Okay.
All right. Thank you.
You're
At
welcome.
this time, Your Honor, we'll be requesting approximately a 1 month adjournment. Ms. Suttle, this is working towards paying restitution. Work toward the restitution added. She just needs about 1 month to pay that last amount. She did just make a payment of $1,000. So she is making good progress. She just needs the last little bit of time to pay that last $300 for restitution.
Okay. You have a green sheet? I don't have a problem. I'm sure there's no objection from the people. April 24th.
Thank you.
2025, 9 a.m. or as your invite indicates, we'll continue. All right. Thank you, ma'am.
Thank you, Your Honor.
Court calls the case People versus Davian Thomas.
And for the
Your name?
Your Honor,
All right, what are we doing?
today is the date and time for the cause conference. This matter has previously been adjourned so that Mr. Thomas can complete litigation with the social work team. That has been completed, it's been provided to the people who are asking for adjournments that need to be considered, and we also need to determine restitution.
April 17th, 2025, 9 a.m. Do I have a green sheet?
I do.
Bond will continue. Thank you. Thank you. Court calls case People versus Delco Thomas.
I was born great on that Delta Thomas. Your Honor, I have been unable to reach Mr. Thomas. I'm not sure.
Delco Thomas, your bench warrant. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately. Court calls the case People versus Matthew Turner.
On behalf of Mr. Turner, who appears on Zoom. Mr. Turner, would you unmute and state your name for the record?
Matthew Turner.
Got it.
Your Honor, the defense would like to request an exam.
All discoveries complete.
Yes.
People have their witnesses available the 8th. Preliminary examination in person, April 8th, 2025, 9 a.m. before Judge Barr.
All right, thank you.
Bond continued.
Thank you.
Court calls the case People versus Adrian Vasquez.
To my right.
Adrian Vasquez.
Thank you.
Your Honor, my client is going to go ahead and set this for a preliminary exam.
All discoveries complete.
That's my knowledge.
People have their witnesses available the 8th. Preliminary examination in person, April 8th, 2025, 9 a.m. That is before Judge Valvo. Bond will continue. Thank you. Court calls case People versus Jelani Wright.
Stephanie Cannon, we have Mr. Wright, who's appearing to my right.
Thank you.
Your Honor, I did have a little issue getting in touch with my client, we'll say, so I'm just asking for a couple weeks adjournment so that he can go over everything that I do have. We did ask for security footage and one other piece of discovery. It's come to my attention that I've been told they don't have it. So at the next hearing, we'll either be sending it for a preliminary exam or giving it up.
April 10th, 2025, 9 a.m. Bond continued.
April 5th, Your Honor.
10.
Thank you.
Court calls the case People versus Ernest Cesar.
Your Honor, Alexis, my appearing on behalf of Mr. Cesar, who I do not believe is present today. Your Honor, wasn't able to get a hold of Mr. Cesar. Was going to just ask for an adjournment. In this case, he was referred for mitigation report from our social work department. We just started that process and had an interview this past Friday. So that report is not yet ready.
Bench warrant will issue for defendant's failure to appear. Bond $10,000. Cash surety. That warrant will issue immediately. Court calls case People versus Makisha Malcor.
Andrew Childers, attorney on behalf of people, assistant public defender, Jay Long, on behalf of Your Honor, we're here for PCC today. My understanding is that we adjourned this case last time so that Ms. Melcher would be able to enter into treatment and complete that treatment. However, the court recalls her fiance passed away recently. She did have to take that time, unfortunately, to move her things out of that home. She just showed me proof that she's going to be entering positive images in Detroit today, right after court. I would ask for another month so that she can get in and complete that treatment.
Any objection from the people?
No objection.
Is that a 30-day program?
30 plus, it's just about.
Gotcha. So let's do this. Let's adjourn this out May 1st, 2025, 9 a.m. That we have a better handle on where she's at if she's going in today.
Thank you.
All right. Thank you. Court does call the case of the People versus Eric Smith.
Public defender Natalie, Mr. Smith, Your Honor. I called him at 12:05 when this afternoon I received a notification from the court that he needs to be in person today, that the case was authorized. I did call and speak to him. He did inform me that he didn't have transportation to get here by 12:30. I told him to do everything in his power to try to do so. I can tell the court that I do know for a fact he's not driving right now. He also has a leg injury. His mother is his transportation. I met with him in person here in the office last Wednesday. His mother drove to that meeting. They both came here together. He had the cast on his leg and his bed last Wednesday. I would ask the court to adjourn this matter so that he can come in person and have his ride scheduled possibly next week or the week after. I do believe he would be able to get here in person if he had time to arrange a ride. I do strongly believe that throughout my representation of him.
Your Honor, I did want to place on the record, this morning I was checking the warrant entries and I saw he did have a warrant. I authorized charges of misdemeanor domestic violence and malicious destruction of personal property, I believe 200 to 1,000. He was at the victim's house. He's not supposed to be able to shoot the victim in the case we are currently on. And he was at her house, broke her TV, pushed her in the face. So kind of similar instances.
Was that after his arraignment on this case?
This was this morning at 1 a.m. He was there.
Oh.
Yes. So he did get picked up. He was at her house ready to assault her and broke her TV, pushed her in the face.
So he could get a ride there.
Your Honor, the first I've heard of any of these allegations that.
Yeah, I know. You know, you can say that word as loud and as long as you want, but.
The first I heard of this was during the 9 a.m. block, and Zenda did tell me about the new case was in the warrant queue. To my understanding, based on those allegations at the time, he was not arrested on scene or anything of that nature. To my understanding, I firmly believe he would get here in person if he knew far in advance that he just doesn't have transportation today.
And in the report, it says that other deputies were able to find his vehicle outside of his residence. They attempted to make contact, but no answer. So they did get a chance to talk with him. Seems not at the scene. I also wanted to put on the record there was an offer given this case at this time.
Anything else?
I would ask for a very brief adjournment, Your Honor, so that he can get here in person.
Bench warrant will issue for defendant's failure to appear. Given what I've heard, there'll be no bond. That warrant will issue immediately. So if he doesn't get here, then we'll get him. Oh, yeah. Gotcha. Court does call the case, People versus Caleb Smith.
Thank you, Judge. Good afternoon.
Good afternoon.
Lawrence Margolis on behalf of Mr. Smith, being the time set to BCC, as we'll be at length with sisters, and we are going to waive the exam.
Is that a correct statement, Mr. Smith? You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them. You understand you'll not have that hearing and you'll proceed to circuit court for further resolution. People also waive their right.
That's right.
Preliminary examination having been waived, defendant is bound over to circuit court on all 4 counts. Mr. Margolis.
Judge, we would waive the formal reading and ask for enter pleaded not guilty.
Defendant, having waived formal reading, pleading not guilty, court will enter that not guilty plea as to all counts. Pre-trial in this matter.
May 15th at 1:30 p.m. with Judge Slay.
May 15, 2025, 1:30 before Judge Slay. Young man, how have you been doing?
Focusing on school. Just chores around the house.
You doing chores around the house? You weren't doing those before?
No, take you an update.
I hate talking to kids about chores because they're not telling me the truth. Mom, is he doing the chores around the house?
Painting the walls.
Really?
Yeah. I volunteer.
So he's painting?
Yes. Almost.
Can he paint?
Yes.
He doesn't? Oh, just, okay, all right. She said, I don't trust him with all the colors. Young man, you've been through some stuff here, right? I don't do it to be mean to you, but I'm just going to tell you, there are going to be a lot of times you're going to come across some stuff in your life where you're either tempted to do something or whatever. Think back to the moments that we've had here as an example of some of the bad things that can happen if you don't make the right decision and don't do what your mama taught you. You hear me?
Yes, Your Honor.
God will continue.
Thank you, Judge.
Thank you.
Thank you for having this case.
Thank you. Yeah. Thank you.
I will continue to report the court.
Please do. Because I don't need a court to ride up on you. You hear me?
Yes.
I'll just, if you see a big Ford truck coming at you, you know it's me. All right? Hey, take care. Tonight, we don't need luck. Your team. You just call him your team. He must be a Spartan. He must be a Spartan because he doesn't know how to spell terrapin. Oh, is that okay? Wow. Court calls the case, People versus Quenisha Thomas.
Your Honor.
And good afternoon, Your Honor. Sydney Russian of who happened this house, who was approaching the reason my life petition in the case. Thank you. Your Honor, at this point, we need additional time to complete the discovery.
All right. 17th work for you?
That's the judge.
Probable cause conference will be adjourned April 17th, 2025. 9 a.m. as your invite indicates, bond will continue.
Thank you so much.
All right, thank
Have a
you.
great day.
You do the same. Court calls case, People versus Lawrence Savoy.
And here between the people.
Thank you. All right. Have before me a plea form. Is that what we're doing?
Yes, Your
He's going to plead to OWI second offense, the 1 year offense. Upon a successful guilty plea to that charge, count 1 would be dismissed. Counsel approach, please. All right, record should reflect you had a bench conference in this case, and we're going to go ahead and plea. He has signed an aggressive. Yes. All right. May I have him sworn?
You solemnly swear to affirm the testimony you about to give is the truth, the whole truth, and nothing but the truth, so help you God. Raise your hand.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated second offense. Is that correct? That is a misdemeanor. It is punishable by up to 1 year incarceration, up to a $1,000 fine plus court costs. I think that's right. Court could order community service and any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could also order your vehicle forfeited, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir? All right. And understanding that, I should also advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. Understand that?
Correct.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind?
Correct.
All right. You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights? Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right. Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead? Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will because you believe that you are indeed guilty of this offense?
Yes, sir.
October 31st, 2024, at the location of William in Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, sir.
What'd you have and how much?
It was a couple of documents.
All right. Were you stopped by the police or was there an accident?
Stuff like
All right. Why'd they stop you?
speed.
All right. Were you ultimately arrested?
Yes, sir.
You were taken to the station or the hospital?
At first the hospital, Your Honor, and then blood drawn.
Okay. So there was a blood draw at the hospital? What were the results?
Stipulated was 0.127 blood test.
All right. You don't have any reason to dispute those blood test results? No. All right. And had you previously been convicted of operating while impaired on or about August 29, 2013 in 14A3 District Court and or operating while intoxicated on or about August 3rd, 2017 in the 48th District Court?
Yes, sir.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People will set a precedent.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B. Probation sentencing will be
May 15th at 10 a.m.
May 15th, 2025, 10 a.m. before Judge Washington. Bound with its conditions will continue. All right, thanks. Court does call the case of the People versus D'Angelo Green.
Andrew Joyce, and on behalf of people on behalf of this grant, please introduce yourself to the court.
What are we doing?
Today is the end times at the probable cause conference. We have reached an agreement where the people will be dismissing count 1. In exchange, Mr. Green will be pleading guilty to counts 2 and 3, the driving without a license and the no insurance charge. The people also agreed to not charge a count for brass knuckles that arose out of this incident. That's more for the record, the last, but the uncharged part.
So he's going to be pleading guilty to counts 2 and 3. Count 1 will be dismissed. May I have him sworn?
Solemnly swear to affirm the testimony you about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Sir, it's this court's understanding that you're going to be pleading guilty to the charge, to 2 charges. 1, of operating a motor vehicle without security. That's a misdemeanor punishable by up to 1 year incarceration, not less than $200, not more than $500 fine plus court costs. You understand that?
Yes,
All right. And also to count 3, which is driving while license suspended, denied, and or revoked. That's a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. Your vehicle could be subject to immobilization. You understand that, sir? Understanding all that, still wish to plead guilty to the charge of operating without security? How do you plead? To the charge of driving while license suspended, denied, and or revoked? How do you plead? Now, you understand that by pleading guilty, you will not have a trial of any kind. You signed an advice of rights form, is that correct? Any question regarding those rights? Look on the podium, look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you? You're doing this voluntarily, of your own free will, and because you believe you're guilty? Okay. On November 18, 2024, at the location of 4001 South State Street, Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle? Did you have proper insurance and or security for the operation of that vehicle?
No.
Did you know that you did not?
Yes.
All right. On that same date and at that same location that you were operating this motor vehicle, did you have a driver's license?
Yes.
Was your driver's license suspended, denied, and or revoked at that time?
It was suspended. I was unaware at the moment.
All right. Okay. So it was suspended, correct? Okay, and you are not disputing that the Secretary of State sent notice of that suspension to your last known address? All right, counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea? Court will accept the defendant's plea to counts 2 and 3. Count 1 is dismissed.
Just a bit of extra, this plea came out of an agreement between Ms. Blondie and Mr. Burdell. The defendant to complete 20 hours of community service, which eventually applies to that. People would have no objection to the immediate sentence.
Okay.
And he also did complete a gun safety class as well. He is currently insured and his license is valid as well. We would ask for immediate sentencing at this time as well.
You say he has valid insurance at this point?
Yes.
And your license is good, whether you know it or not? Okay, all right. So anything either of you want to say before I impose sentence?
No, Judge. Mr. Green has learned from his mistake and he's ready to move forward. He's cleaned up his licensing issues and his gun issues. We're I'm confident he'll never need my services again. We just ask for immediate sentencing and fines and costs only.
On each of the counts, assess fines and costs of $295 on each count. Suspend 90 days in jail on each count. When can you get that paid, sir? You can pay those immediately?
Yes, sir.
It's about 600.
About my next paycheck.
So I don't know when that is.
1 month, Your Honor, would that be able to give him a month's pay?
A whole month. It went from today to a month? It's Burdell's fault?
No,
it's not his fault, it's your fault.
I'll follow that, Judge. I'll follow that. So just to, give him a little extra leeway just in case.
Pay it by April 30th.
Thank you, Judge.
All right, 2025. All right, bond will continue. Thank you, sir. Court calls the case People versus Bianca Rao.
Good afternoon, Your Honor. Victoria Burton here as Chief Assistant Prosecutor on behalf of the people.
Hi, Burdell, on behalf of Ms. Rao.
Hello. Seems kind of happy. All right.
Your Honor, that may be because we did receive an offer from the prosecutor, which we are intending to take. That will require her, Ms. Rao, some time to complete some terms.
Okay.
So we are asking for a 30-day adjournment to allow her time to complete things.
No objection from the people?
No objection.
All right. Probable cause conference on adjourned to May 1st, 2025. 9 a.m.
Thank you, Judge.
Bond will continue. Thank you.
Thank you, Your Honor. Have a wonderful day. You are all set.
You do the same. Be
Thank
well,
you.
please.
Thank you.
Court calls case People versus Ahmad Holiday.
So the attorney for the people.
Oh. Mr. Murray, did you want to state your appearance, please?
Oh, I didn't hear the people. My apologies. Good afternoon, Your Honor. James Murray, PA 5490 on behalf of Mr. Holiday. Please state your name for the record, sir.
He said it very well, but he was muted.
Unmute and state your name for the record.
My apologies, Ahmad Holiday.
All right, thank you. All right, what are we doing?
Your Honor, I sent the deviation request to the people, but I have not had a chance to discuss that with them. If maybe we can, might be hard to go into a breakout room, a brief phone call and then come back to the record.
No, that's not going to happen. All right, you guys can use the phone anytime. You don't have to use it on my time. So I'll adjourn this out April 10th, 2025, 9 a.m. or as your invite indicates, bond will continue.
Your Honor, may I address bond?
Sure.
At this time, my client is currently on home confinement tether, and while we have no objection to the tether at this time, the home confinement portion of his restrictions do prevent him from working, so we just ask that it be switched from home confinement to GPS tether.
Any responses?
Your Honor, I would not have an objection if the defendant provided where proof of employment, date, time, location of where he's going to be working.
Okay, so why don't we do this? Since you got to come back on the 10th in any event, I'm going to deny your request at this time. However, if there's a stipulated order after you supply all of the information and talk about the case with the prosecutor in the case, I will sign off on it. I don't have a problem with it.
No, that sounds perfect, Your Honor. Thank you.
Thank you. So bond will continue as it is at this time. Thank you.
Great day to you and your staff.
Court calls case People versus Donald Spaulding.
Sophia Curry, if you're going to have people.
Good afternoon, Judge Arnold Weiner, on behalf of Mr. Spaulding. Mr. Spaulding, state your full name for the record, please.
Donald Spaulding.
Thank you. Judge, this is the date set for another PCC. Last time the court adjourned it so we could see if we could get the discovery materials. The people have worked diligently and provided me all the videos that were in there. The only thing I am waiting for, and I think the people are waiting for, which would really make a decision whether or not we go ahead with the preliminary exam, is whether or not they have any lab results back on the bag of drugs that they found. I was specifically looking for whether or not they had any fingerprints or DNA taken of that bag one way or the other. So that's where we're at. But as of a couple of days ago, I was advised although they were working very diligently, the MSP has not provided them with that information. So that's where, at least that's what I understand.
Please.
We did provide discovery back in November of 2024. And I believe there may have been court-appointed counsel, so that discovery was provided to Mr. Weiner. And we just recently provided Mr. Weiner with the MSP videos. However, I did reach out to the OIC to have the controlled substances sent to the lab for confirmation. There was a true narc done on the controlled substances. But as far as DNA, if Mr. Weiner wants to stipulate to an order to have the DNA testing taken from his client,
and make that request. We could send the narcotics to the lab along with his DNA for comparison, but that's not something that, based upon the facts of this case, we don't need DNA at this point to proceed for a probable cause standard, and I don't even think at trial, based upon the facts that we have.
Okay, well, I just wanted to know, Judge, that whether they were proceeding with or without, that there was DNA or fingerprints on the baggie. So if that's their
Sounds
position,
like that's without.
Yeah, I'm ready to set a preliminary examination date then. Thank you.
People have their witnesses available the 8th.
Judge, can we go other than what dates does this court prefer to do it on?
Well, it may not be me, but we do them every Tuesday.
I tell you what, if I'll be available on the April the 15th, if it could be done in the afternoon, or April 15th, I'll be available in the afternoon, Judge. If we could do that.
All right, counsel, just give me a Tuesday morning.
The 29th, I'm free, and I'll mark that off right now.
The 29th? Hold on.
April 29th, yes, sir.
All right, so I'll set preliminary examination in person, April 29th, 2025, 9 a.m. That will be before Judge Barr.
And that's going to be at what courthouse, Judge?
That will be at 14A1. That'll be at the Service Center.
Okay, thank you.
It's at the same courthouse that I'm in.
Okay. Oh, one off.
Okay.
Hog back right there. Okay, gotcha.
Yes, sir.
Thank you.
All right, thank you. Bond will continue. Court does call the case. People versus Jack Monitz.
Amber Children's appearing on behalf of the people.
Josh Captain on behalf of Jack Moniz. Jack, will you state your name for the record?
Jack Moniz.
What are we doing?
There's been an offer in this case. It's my understanding that the defendant would be pleading guilty to count 2, the aggravated assault, even with this count 1, assault GBH. There is no objection to the defendant to seek firearm.
And Your Honor, that is our understanding of the plea, and we do accept that.
All right. Count 2 and dismiss count 1. All right, Mr. Monitz, if you please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
State your name again for the record.
Jack Moniz.
All right. You can put your hand down. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of aggravated assault. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
And I also do have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court. You understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand that, sir?
Yes, Your Honor.
Do you understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No.
I'm sorry, you broke up. Your response?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today? I may have said that one. Has anybody threatened you or coerced you in any way to get you to plead?
No, Your Honor.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes, Your Honor.
And because you believe that you indeed are guilty of this offense?
Yes, Your Honor.
October 10th, 2024, at the location of 1015 Rapid Run Circle, apartment 206, Scioto Township, Washtenaw County, state of Michigan. What did you do to a Charles Chad that makes you think that you're guilty?
It was a verbal altercation turned physical.
Okay. So what happened?
Basically, he ended up coming there, like following my girlfriend, stalking her.
Your Honor, if I may I butt here?
Please, yes.
Mr. Wade, on the night that has been mentioned, did you go outside and meet with the complaining witness in this case?
Yes.
And at that point, did you hit Mr. I forget his name, the complaining witness?
Yes.
And
you hit Mr. Go ahead.
No, that was going to say, and you hit him, and then a physical altercation occurred after that, correct?
Yes.
I believe that's enough for the case, Your Honor.
And was there are you disputing that he was injured as a result of your hitting him?
No.
Thank you. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
We accept, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be May 19, 2025, 9 a.m. before Judge Fresh Hour.
Thank you, Your Honor.
Thank you. Bond will continue with its conditions. Thank you.
Have a good one.
All right, you too. I thought I was going to have to listen to like a high school romance thing. And it's late. I didn't want to do that. Glad counsel took over. Court calls the case, People versus Jeru Gidby.
Sophia Curry, people.
You're going to able to speak to Franklin? Yeah. Defendant? So just take your holding. Roll for it, get your start.
Thank
Your
you.
Honor.
Sir, Your Honor, that be my works. That's fine. All right. Mr. Goldstein, we missed you.
I'm back.
I know. It warms my heart. Yeah, okay.
First of all, Judge, we need to set this for an exam. I have written discovery. This Curry assured me this morning that there is no electronic discovery. So,
all right.
Not a double check then.
Yeah.
All right.
Knowing this case, I'd be surprised if there is, but yes.
All right. And would the people have their witnesses available the 8th?
I'll do my best, Your Honor.
Ms. Curry knows if there's a problem, we'll work something out.
All right. So preliminary examination in person, April 8th, 2025, 9 a.m. That is before Judge Barr. Bond will continue. Thank you. Thank you, sir.
The season went forward. Okay. Yeah,
What's that about? Basketball season.
Sorry, calls on the line, Your Honor.
Oh no, what you said wasn't out of line. Talking to him is. I mean, I'm just I'm just saying. No, you're okay. Take care. Court calls the case People versus Baiyang Wang.
Okay. What else will be coming up? That the decision is
All right. And you're requesting an adjournment?
Yes, please. We are deep in discussion and probably just one step away from a resolution, but that step we still need to take.
Probable cause conference, April 17th. Will that work? The 10th? You want the 10th?
Yes.
That's right.
Thank you.
April 10th, 2025, 9 a.m. Or as your invite indicates, bond continued.
Thank you.
All right, thank you. Oh, and she left. Can you run? Oh, there she is. Miss Faye? What did I have nothing left other than your bus traveler.
Yeah, she's still not here. It gets in at 3:30, but again, our meeting.
Okay. Were you able to talk to Miss Burton Harris? She signed up.
That information, she has not responded. One period.
Okay, so she has a meeting with Community Corrections at 2.
Ms. Nobles does, yes.
Miss Nobles does? All right. So rather than waiting, and you can try to get to her when she arrives at 3:30 or whatever. Okay, I think what I'm going to do. Was anybody going to cover this for Miss Burton Harris?
I can.
They all looked up like, what? That was it? No.
No, I was gonna say, I can also send her a message, she might reply in like 2 seconds. Oh, back on it, 2. We all? Yeah, here, we'll stay.
For fun.
It's a big family. What it is.
But she gets off the bus at 3. What time is it? Oh, so we're just another 20 minutes from her getting off. And then you may be able to contact her, right?
I've been kind of talking to her. I think I can talk to my boss.
Oh, good. I guess that would make sense. It's not an airplane. Okay. I don't even know what I was thinking. All right. Did she have a preference?
Ms. Nobles?
Yeah.
No, I've not talked to her about that.
Okay. So let's do this. It's only another 20 minutes. Why don't we just wait it out, let her get in, and then we can see where we can head with it. And I've been assured I'll have a prosecutor here. So that's you know what? Write it down on a piece of paper. I'll write my favorite cherries on a piece of paper. Let's see if it matches.
But
what?
my favorite.
Wow. Wow. When we call that case, that ought to work out real well. All right. Wow. And Kate just said it out loud. She just. Yeah, but we know it's not. All right. Wow. You know, when she first came here, she was so quiet and demure, and something happened. All right. Anyway, what I will do is I will step off. You'll apologize to your folks, and then we'll see what we're going to do once she gets in, okay? Court does call the case of People State of Michigan versus Robert Noble.
If you ever jump in for people.
Yes, ma'am.
Assistant Public Defender, Ms. Robin Noble. Okay. Hey there, Robin Noble.
All right. So, okay, I have a violation from Community Corrections. So, did you want to address that first?
Yes, Your Honor. And I have received that and had the opportunity to discuss that with my client. And the vet was able to confirm with Community Corrections that Ms. Nobles did then reach out to Community Corrections this morning and scheduled her intake appointment. It is set for tomorrow at 2 p.m. Ms. Nobles did yesterday evening, upon learning of now the in-person requirement for today's hearing, she purchased a Greyhound bus ticket, not Greyhound bus, another bus line. In any event, she made it here and she is planning on staying with her sister in this area so that she can complete that intake tomorrow and test at Community Corrections as needed. I have been in discussions regarding this case with Ms. Burton Harris. Ultimately, we're requesting a 2-week adjournment. I believe in the case of one that's going to be resolved, I will be asking for 2 weeks so that Ms. Nobles can complete her community corrections intake tomorrow afternoon, get on testing there, and then the resolution at that date.
Anything from the people regarding any of that?
No, I am standing in for Chief Assistant Burton Harris. I have not had an opportunity to discuss this case directly with her in the circumstances. However, I was present earlier during the docket where she was aware that Ms. Nobles was on her way. I will take counter representations, and her word is true. And I have no objection to the adjourned requesting her.
Probable cause hearing will be adjourned to April 10, 2025 at 9 a.m. Were you testing in Grand Rapids?
No, so I was supposed to move in on Wednesday, but my original bus ticket, the public transportation and delivery didn't pick me up on time, so I missed that very home. And the next ticket that I was getting, it was scheduled to come here. As I learned that I was supposed to be transferred. But I am still supposed to be there. I am communicating with the property owner in recovery room, and they know that I have 4 papers. I let them know everything that I have going on. I still think we'll get. I just want to make sure.
Move in where?
In Grand Rapids. That's the sober living facility.
Because, so 10 days ago, when I ordered that you could test in Grand Rapids, and it was supposed to be 2 times per week, there's been no testing.
I did directly confirm myself with Ms. Kerhoke over at Community Corrections that she does have her intake scheduled for tomorrow.
28th. Right. What I will do is I'll adjourn it to the 10th. Her bond will continue. I will indicate a condition in that bond is that she's to complete her intake at Community Corrections and to test tomorrow. All right. Okay. Anything further?
Yes, sir. Nothing further from her.
All right. Thank you.
Today's courtroom session presents a series of ongoing legal proceedings being conducted through a virtual and in-person hybrid format. Multiple participants are present across different locations, including legal counsel, court officials, and the presiding judge overseeing the docket. The court is currently reviewing several criminal matters, with each case being addressed in accordance with standard legal procedures and courtroom protocol. Throughout the session, the judge maintains control of the proceedings, ensuring that all parties are given appropriate time to present their statements and respond to legal questions. Legal representatives appear prepared as discussions continue regarding case details, procedural matters, and scheduled rulings. The defendant is present for questioning as required by the court, while the proceedings remain structured and orderly under judicial supervision. As the docket progresses, the court continues to evaluate each matter individually, ensuring that due process is followed in every step. This session highlights the formal nature of courtroom proceedings, where legal arguments, evidence review, and judicial decisions are carefully examined. We will continue to follow this docket as further developments and rulings are made available.
Oh, no, not, no, anybody but McDuffie. You got everybody there to choose from and you pick McDuffie. Okay, Miss McDuffie, go ahead.
Good morning. The people waive any conflict between this honorable court and the office of the public defender for all cases on today's docket. The people do not believe that a conflict exists, but we make this waiver for the avoidance of any nuisance.
I'll blame you, Childers. Oh, I get a choice? You know who I'm choosing. No, Miss Mackey?
Rule 8.120 under Deputy Chief Laura Brown.
Permission to practice is granted.
Thank you, Your Honor. Honor, removing any potential conflict with the honorable court and our office of the city conflict supervisor, remove that conflict with the honorable court in these matters.
Thank you. That was so nicely done. The court, for its part, does not believe that there is any conflict either under the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of People State of Michigan versus Gene Giles. They're all on Zoom.
Good morning, Your Honor. For the record, Rita Young, P44626, appearing on behalf of the defendant, Mr. Gene Giles, who is present by Zoom.
Sir, can you state your name?
Gene Gillis.
Gillis. All right, thank you. All right, what are we doing on this?
Your Honor, requested a preliminary examination in person.
And you have all of the discovery?
I'm still waiting on the DNA test results, Your Honor, but I don't want to, we've been waiting for a while, so I want to move forward. Hopefully the prosecutor will provide those documents before the exam date.
I have a note from APA Lonnie from the last CC where she stated, she sent an email to Ms. Young, and Ms. Young actually replied to that with confirmation. She stated that she was able to confirm with the plan that there will be no further testing in this case, so we can go ahead and send this for exam. So no DNA results are important.
There, did you hear that?
Not clearly, Your Honor.
There'll be no DNA testing. There's no further testing. There'll be no DNA results coming.
Okay, very well.
All right, since we got to arrange for transport from MDOC, preliminary examination in person will be set April 22nd.
Judge, I have a conflict.
Pardon?
I'm so sorry. I start a homicide trial in Wayne County on the 21st. That's going to last about a week.
April 29th, 2025, 9 a.m. That is before, that's before me.
Okay.
Just call me lucky. All right, thank you.
Thank you, Your Honor.
Bond continue. Thank you, sir. Court calls the case, People versus Robert Braxton.
Morning, Your Honor. This is for David Bergson and Robert Braxton, who's appearing via Zoom.
Mr. Braxton, can you state your name, please, sir?
Robert Braxton?
I have before me a plea form. Is that what we're doing?
It is, Your Honor. I discussed it with my client. He's ready to proceed.
All right. Plea form indicates that the defendant will be pleading guilty to 2 charges, added counts 5 and 6. The 5 being attempted possession of a firearm in a motor vehicle, a misdemeanor punishable by up to 1 year incarceration and a $1,250 fine plus court costs, and an added count 6 of attempted resisting and obstructing a police officer, also a misdemeanor punishable by up to 1 year, $1,000 fine plus court costs. Upon a successful plea to that charge, counts 1, 2, 3, and 4 would be dismissed, and there's no objection to a time served sentence. That's the court's full understanding of it.
That's perfect.
Mr. Braxton, can you raise your right hand, please, sir? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name again for the record, please.
Robert Maurice Braxton.
Sir, it is the court's understanding that you're going to be pleading guilty to 2 misdemeanor charges. First charge being an added count 5 of attempted possession of a firearm in a motor vehicle. It's indicated that's a misdemeanor punishable by up to 1 year incarceration and or a $1,250 fine plus court costs. Do you understand that?
Yes.
It's also this court's understanding you're going to plead guilty to an added count 6 of attempted resisting and obstructing a police officer. That being a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge unless we proceed to immediate sentence. But you understand I would not be your sentencing judge. We would be sentenced before Judge Washington in the 14B District Court.
Okay, I thought I was gonna get sentenced today.
Mr. Braxton, but I'm not sure if Judge Simpson's going to or not.
They never know what I'm gonna do.
Okay.
All right. The good thing is neither do I. What?
I would be fine with immediate sentencing in reality as the count to the attempt.
Yes, it is. I have to send it to Judge Washington. It's a DR. You're right. All right. So you understand that, sir? Mr. Braxton? Yeah, we've lost it. I've lost the audio. Let me pass the matter. Can you put in the chat so that you can? Okay. Court does call the case People versus Jenny Liu. 2 cases.
Assistant Public Defender Chelsea Gerville, with and on behalf of Jenny Liu. State your name.
Jenny Liu.
Good morning. All right. You're asking for an adjournment of this.
We have been able to do further results and perjury on another case attempting but unsuccessful
To
follow the process of getting a visitor and then scheduling. Ms. Tierney has gotten her step 1, but now she's having to go to step 2. I have not even approved as a visitor, unfortunately.
All right. Is anybody in your office aware of how much time this is taking? Because this is the first case.
We are definitely aware and we apologize for that, but we are trying to follow the extensive instructions provided to us by Grand Valley's facility.
Right. I understand that, but are we looking at a month or are we looking at a shorter time?
I would say a month to be safe. Now that Ms. Kearney is approved, once the scheduling spot opens, she should schedule that and discuss the offer with me.
All right. Probable cause conference, April 24th, 2025, 9 a.m. Bond will continue. Thank you, Ms. Liu.
So Judge, am I just waiting for them to come see me?
In part, yes, they have to come talk to you, but they've got to get through the process to even be able to have a visit with you.
The visitation. Yeah, I was aware that. I thought they had already got that all cleared up.
Whatever it is, not just because of your case, but it seems to be a mess on NDOC's part, trying to get people approved. So I know they're working on it hard with your case and with other cases. All right?
Okay, sir. Thank you.
All right. Thank you. Court calls the case of People versus Devin Gibson.
Please, report Brandon Bird on behalf of Devin Gibson.
He's in. Okay.
Yes.
Sir, can you state your name?
Me, Devin Gibson.
All right. What are we doing? You're requesting an adjournment?
Yes, ma'am.
Probable cause conference will be adjourned. It's 2 weeks out, the 10th. April 10th. Will that work for you, Council? April 10th, 2025, 9 a.m. Your invite indicates bond will continue. Go ahead.
18-year-old lifelong resident. He is focused on possession and since matter. You do have his father here to support him, so he has significant community ties. He understands that there's going to be no contact between the witness and respectfully honored. My client indicates to us that even if he needs his tether,
Go ahead. You know what I'm saying?
we respect to let the person find the tether, at least to lower it.
Response.
Thank you, Your Honor. First, I want to ask you, the court has a copy of the prosecutor's bond recommendation form in its file.
I do.
I wanted to ask if the court would respond to that. You will see that, the authorizing APA on this case originally requested a cash or financial bond of $500,000 in debt surety. I believe that what was actually ordered was significantly reduced now, if I'm not mistaken, of 50,000 with a 10% privilege on top of that. I think the recommendation form will get into detail about some of the concerns on this case. There is GPH charged, and there is apparently a very bloody statement to the residents, including several counts of RNO with damage to a police vehicle and an ethnic intimidation charge as well. So we're very concerned about the safety of the community in general based on what happened. So the people would ask that it's significantly responsible for originally requested.
Anything additional, Council? Motion for bond reduction is denied. Bond will continue. Thank you.
That's it, Craig.
Court calls
You
the
do
case
that
people
today, girl,
versus
once you put her
Warren.
hands on me, though.
Oh? Do we need to go back up? Okay, no. No? Leave it alone? Okay. You're a nicer person. Court calls the case people versus Warren Abbott. Wow, in the room. In the room. In the room. Thank you, sir.
And Your Honor, I spoke to my client about the options that he has. He has elected to waive over to circuit court.
All right. Is that correct, sir? You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand you'll not have that here. You'll proceed to circuit court for further resolution. People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on a single charge. Ms. Cannon.
Your Honor, at this time, my client will waive for information. He can read as to the charges.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for April 9, 2025, 1:30, Judge Conlon.
Thank you, Your Honor.
Thank you. Bond will continue. Court calls the case of People versus Rafael de la Cruz.
Good morning, Your Honor. This is Robert Ianni, Special Assistant AG on behalf of the people.
Hunter Alexis, my appearing with on behalf of Mr. De La Cruz.
State your name, sir.
My name is Rafael de la Cruz.
All right, thank you.
And Your Honor, we are requesting an adjournment. Mr. De La Cruz posted bond at the end of February. Since then, he's paid an additional $2,000 towards his arrears. So we are just asking an adjournment.
Any objection from the people?
Yeah, we would like to see him start making monthly payments, Your Honor. He does have 2 children in need of support. I mean, I don't mind dragging this case on as long as he's making his monthly payments.
How much are his monthly payment?
Your Honor,
$350, Your Honor.
$350. He paid the additional $2,000 at the beginning of this month, which went obviously toward the arrears as well as his monthly payment. So
That's correct.
All right. All right. How much time were you looking at?
if we could go out a month.
Probable cause conference, April 24th, 2025, 9 a.m.
April 24, have it, Your Honor. Thank you.
Thank you. Bond continue. Court calls the case People versus Stephen Bauer.
Again, Your Honor, for David Burns, on behalf of Stephen Bauer, we approach. Stephen Bauer?
All right. And you're requesting time to get the
2 weeks, Your Honor.
2 weeks to do?
Pretty much to review this discovery, and we're not sure if there is additional discovery, but we need to review it. So we request to. That's correct, Your Honor.
April 10th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus James Belleville.
Ever heard somebody have to James Belleville?
Mr. Belleville?
Yes, Your Honor.
Good morning, Your Honor. We have been working on paying restitution. We tried to check to, but I understand that there's pay restitution that's in cash.
Yes.
So I'm going to look at it right.
And it needs to be paid at 14B. Yes.
I'm going to work on facilitating that and I think next 2 weeks.
2 weeks. Without objection, probable cause conference April 10th, 2025, 9 a.m. Bound continue.
Thank you, Your Honor.
Thank you, sir. Court calls case People versus Stevie Brooks.
Yes, Your Honor. Rutherford on behalf of Steve Brooks.
Thank you.